Good morning, good morning, good morning, amazing law nerd. How are you? Did I forget my earrings? I did. Don't worry. We'll fix it in post. I'll put them on in a minute. It's going to be fine. It is Wednesday. It's April 8th. We have much to talk about. Why? Well, I have a conundrum, law nerds, but we have so much to cover that we had not gotten to, all related to the Idaho defamation case. I had put out just very brief YouTube shorts and app notifications regarding the TikTok psychic trial. And today we have so much to talk about with that. I know there are other things going on in the law today. This is what we're doing today. We'll find earrings in a second. Don't worry. This is what we're doing today. Look, I grabbed a cookie. We're a month away from Banfield sentencing. We're ready to go. We're just ready to go. But you guys, there is so much happening in the TikTok case. And some of you are going to be like, you don't say anyone's name. No, I don't. I've talked about it since the beginning of the TikTok psychic case. No, there will not be a face in a thumbnail. There will not be a name. There will not be infamy based on my coverage. And we are going to talk about all of the nonsense and another lawsuit. There's another lawsuit. But I have a quandary we're going to have to discuss together. Those of you that are here early, and y'all are here early, those of you that are here early are going to get to help me decide how to deal with the quandary. So I'm going to roll the intro, see if I can get my earrings on during the intro. Let's race and see. But we have so much to do today. Are you guys ready? I'm ready. It's April 8th. It's time to go. So let's go. Hey there, I'm lawyer and legal analyst Emily D. Baker, and this is your go-to destination for live court coverage. I break down the law, the strategy, and the evidence in real time so you know what's happening. No law degree required. So join the law nerds in the chat. They're here for the facts, not and let's get to court. We got our earrings. I know, chat, you are impressed by my giant cookie. I know, it is the biggest cookie in the world. My friends at Wildgrain sent it to me in my Wildgrain box that I ordered. But same. Don't worry, Wildgrain is our sponsor today. We're going to talk about that in a few minutes. But, you know, this is my quandary. This is my quandary today. Anthony, this is my quandary. What's with today? This is my quandary. You guys, it's Rex Manning Day. And here's the thing, though. There is a case that we have not talked about on this channel at all because I was just waiting to see what happened. And he pled today, and it wasn't streamed. So it's also like Rex Heuermann Day because the Long Island serial killer pled today. This is like breaking news, but it is not what's on our docket today. I might cover that tomorrow. But yeah, for those of you that are just like, what the heck? Yeah, it's Rex Manning Day. I don't think I can give it over to Lisk. I don't think I can make it Lisk Day. He pled guilty today. We'll do it as a quick bit. We can do it as a quick bit, but he pled guilty today. I'm contemplating covering it tomorrow because we will have so much more information if you guys are interested. Because today there is still so much breaking news that is currently ongoing, and I wanted to cover this. But New York did not stream it. There will be press conferences. We have not gotten to those press conferences. If you're interested, we will cover that tomorrow and just go through an overview of the case. For those of you that do not know it, go through the plea, what the plea means, go through the press conference from the district attorneys that still I don't think has happened yet. There's a civil law. There's a lot. All of you are like, cover it tomorrow. Okay, perfect. Well, we'll just cover it tomorrow. Say no more. No more. Because I feel like today gets to be Rex Manning Day and Lisk can wait till tomorrow. Like he's been maintaining his innocence since he was arrested. This is a case a lot of you have followed. Some of you have seen Gone Girls, but I think we should cover it tomorrow. He is actually, I think, quantifiably taller than Banfield, but he's like 6'4". He's a imposing human. But I think we can do that tomorrow because breaking news is difficult. Breaking news can be much, and we're just not even to the end of the breaking news today. So a lot of you are like, let's cover it tomorrow. For those of you that don't know the case, I'll do an overview. It's a serial killer case. For those of you that don't know the case, I'll do an overview tomorrow. And he has been maintaining his innocence. He changed his plea today. I hope that's a huge relief for all of the victim families. He pled to 7 murders, admitted to an 8th that is newly tied to him. So with that, I think we just cover it tomorrow and do kind of instead of a piecemeal, just do an overview of the case, the plea, and what happens next, and then the civil lawsuit. I think that's fair. So with the Long Island serial killer case, we'll talk about that plea tomorrow. There isn't footage of it. A lot of you have asked me about it. Is he the real estate guy? Sina, yes, he's the real estate guy. That's the one. But it is a case that many have followed for a very long time and was supposed to go to trial. I was waiting to see if it was going to go to trial. When I started seeing news that he was going to change his plea, I figured it was probably because they were reaching out to victim families. And then today he actually changed his plea, which is surprising. Appropriate, but surprising. So, oh yeah, architect. Sorry, virtual juror. I conflated real estate, architecture. I conflated them all together. Yes. That. We'll cover it tomorrow. So with that, today is Rex Manning Day. So we can leave Lisk to tomorrow. We can save Rex Manning today. For those of you that are like, what do you mean Rex Manning Day? The movie Empire Records is a absolute 10 out of 10 in my mind. It is a 90s movie. I have not watched it in a minute, but I think, well, we just might have to take a look at Rex Manning Day. I love this movie. It has been a very long time since I have seen Empire Records, which is improper. I should just watch it tonight. But we might need to do a little clip of Rex Manning Day to just give you the overview that is the gloriousness of a bunch of teens, young adults working at a record store and what happens in one day at the record store. I miss this type of movie where 90% of the scenes all happen in one location and it's like a chaotic slice of life in the work, you know. So damn the man, save the empire. It's fantastic. So I think we just need a clip, hold on, of Rex Manning Day. Did I already say that we had a sponsor today? Thank you to the sponsors of the channel that allow me to just do what we need to do when we need to do it. Because before we get into all of the TikTok psychic that's going to make you want to scream, we'll cover this now. I am trying to pull, gosh, tech is just being glitchy today. I am trying to pull up some of your chats regarding this movie, like My Name's Not Fucking Warren, which, by the way, I think of every time I talk to my friend Warren. In my head, it's like, my name's not fucking... Yes, Empire Records. So it's just such a good movie. So I think we need just a moment of what is Rex Manning Day. Rex Manning in the movie is a fictional artist that is, well, I'll let you decide. If you are having YouTube glitchiness, try to restart. But yes, Emily... Sina said, whenever Emily has a sponsor, she gets wild with the copyright. Emily's really thankful to those that let her make the ADHD choices. All of you putting the quotes from Empire Records in the chat are just giving me life. Thank you to everyone who has not seen this movie. You are welcome. You are welcome. You are welcome. It's just, it's Empire Records. You know, it made work. It never has working at a record store seemed so cool as with this movie, ever. Because,
we mustn't dwell.
Oh God, I forgot how much music is in this scene. We're going to do our best.
No.
It's going to be difficult.
No, not today.
Yeah.
We can't.
We can't.
Not on Rex Manning Day.
I heard you one more while.
Not on Rex Manning Day. I'm gonna mute the music. Y'all can sing Video Killed the Radio Star to yourself. By the way, my teen's very first field show of high school, this song played in to Travis's very first high school marching band field show. And he was wearing an MTV shirt when we were out last year. And our waitress asked him if he knew what there's no dialogue, it's just the song. Our waitress asked him if he knew what the very first music video was on MTV. And she was stunned when Travis was like, oh, absolutely. Absolutely. For those of you who are like Ethan Embry, yes. An icon. So yes, this is just going to be this. There's still no dialogue. It is just them setting up for Rex Manning to come into the music store to do an appearance. Yeah, nobody's holding up a phone to take a photo. Right. Still music as they are waiting to meet Rex Manning on Rex Manning Day. Still music, by the way. It's just still going to be music, but it's great music. But yeah, that's how long there's been no dialogue. When's the last time they just opened up a movie for this long without dialogue? Just music. Just music. Emily, you keep muting it. I would like the video to be watchable to the replay crew. So that's Rex Manning on the screen, the fake artist that is doing an appearance at the record shop. If you have seen this movie, you understand what's happening. If you've not seen this movie, you don't understand what's happening. That's Warren. I am waiting till Rex. Oh, we don't even have Rex Manning appearing in this clip. Darn it. I need another clip. Hold on. Because we need the clip of Rex Manning arriving. We do. Emily, this is a terrible idea. It's going to be great. Let's see. We're going to see if we have one. But not on Rex Manning Day with Ethan Embry is exactly what I think of when we get to Rex Manning Day. Today is, in fact, Rex Manning Day. However, Video Killed the Radio Star is going to be music that killed the live stream in 30 seconds. However, just one more time. One more time. It looks like Empire Records is also available on YouTube Premium. Just a note.
Not on Rex Manning Day.
Not on Rex Manning Day. You guys, we can't cover serious cases on Rex Manning Day. Not on Rex Manning Day. We're not doing it. I mean, it's serious for someone today, but let's see if do we have any clips of Rex arriving? Emily, we should have done this prior. Yeah, we should have, but we didn't. And I'm not confident it doesn't have music in it. So we're going to let it be for today. Go watch Empire Records. We can try again. So when A, Rex Manning Day, but B, it just makes me happy. C, it's why we need to cover Lisk tomorrow, because we can't have Rex Manning Day and Rex Lisk Day on the same day. We can't do it. We just can't do it. We can't do both. It's going to be a problem. So, let's see. Okay. So before we jump into TikTok Sidekick, let me tell you what we've got today. Also, if you have not been here for the coverage of the TikTok Psychic, put a 1 in the chat and let me know so I can just get a sense of how much of a deep dive we need. Because I am not sure how much of a deep dive we need. So if you put it in the chat, then I can know how much we need some background. Okay. That's totally fine. I love it. I love it. Because those of you who know this case are just going to be like, yes, we need some background. Okay. Buckle up. We need some background. I love it. Welcome new law nerds who don't know this case. Prepare to be astonished, amazed, and dismayed. All right, we'll do a deep dive. You know what I think we'll do? I think we will thank Wildgrain first. Then we will do an overview leading up to the trial. We'll talk about the trial. We will talk about the post-trial wildness. And then we will talk about the new case. Because there's a new case. Because there's a new case. Those of you that are in the Law Nerd Lounge know what we're in for. Those of you who don't yet, that's okay. There's a new case. We're going to talk about it. So let's do this. Let me cue this up because it seems like the tech on my end is just fighting with me, which means today's going to be, what's with today? Today's going to be an adventure. We love an adventure. We're here for an adventure. This case. There's a new case. There's a new case. But Miguelina, I don't know if you can do a reset. I can't switch between chat, media, etc. None of that is responsive. All of that is not working. So thank you very much. I would normally put the note in the back end, but I can't because nothing is, the back end is crashed and I can't reset it. So we're going to roll that. We're going to get into TikTok Psychic. I'm not going to be able to pull chat up on the screen for a minute. Sorry. It's going to be a problem. And we'll get there. So a huge thank you to our sponsor. I will be right back. I know streaming is dynamic and we're going to thank Wildgrain because, I am using Wildgrain to be prepared for sentencing next month. I'm going to eat this while we share Wildgrain. So I'm very excited. Law Nerds, a huge thank you to today's sponsor, Wildgrain. Law Nerd, a quick thank you to our sponsor, Wildgrain. You know how much I love the chocolate croissant. I talk about it a lot. Eat it frequently on stream, especially when we are streaming trials. And one of the trials we are going to be wrapping up on soon is the Banfield case because we know that his sentencing is coming right up on May 8th. Could we make it Law Nerd International Cookie Day? I think that's going to work. Why? Because Wildgrain has cookies. Big, huge cookies. The type of cookies your friends would bring you for your birthday. And whether you're looking for chocolate chip or snickerdoodle or the molasses, so good. Whether you're looking for vegan or gluten-free, Wildgrain has you covered. You don't have to bake all of them at once. This is the hack that my family loves. Dr. B and I will sit down and make some cookies with ice cream. We will make one cookie for each person that wants one and put the rest back in the freezer. Every product bakes from frozen in 25 minutes or less. No thawing. In fact, don't do that. And the freezing just locks in the flavor and the texture. And they've even added new protein boxes. And they give back. With every box ordered, they donate 2 meals to a food security nonprofit with no extra cost to you, like the Greater Boston Food Bank and others. So if you are ready to check out Wildgrain today and be prepared for Law Nerd International Cookie Day on May 8th, now is the time to take advantage of our discount. Be sure to click on my link in the description or in the chat and use code LAWNERD to get $30 off your first box. Plus, you'll get free croissants in every box for the life of your subscription. That's right, free croissants for life and $30 off your first box with code LAWNERD. Just click the link in the description or in the chat. Thank you, Wildgrain, for providing delicious cookies for Law Nerd International Cookie Day on May 8th and for being a sponsor of today's stream. Let's get back to it. All right, Law Nerd, thank you. And again, a huge thank you to our sponsor. If anyone is having issues on the YouTube end, just go ahead and refresh. For those of you asking, is that a giant molasses cookie? Yes, it is a giant molasses cookie because, well, I love them. I love them. All right. TikTok Psychic. Let's get going. Oh, Renee said, oh, they make pastas too. I eat a lot of wild grain ravioli, especially when I'm in trial because it's so easy to prepare. And I feel like I'm eating a real meal. Though there are some trials where cereal is for dinner. I've been trying to eat actual, a balanced dinner when I am in trial. It cannot always be cereal, though sometimes yes. Let's get into TikTok Psychic. Are you guys ready? I'm ready. I'm not ready. I am ready. It's just going to be what it is. Enjoy the mess. Just enjoy the mess. We're going to, I don't even know how to explain this to those of you that haven't watched this, because it's a whole lot. So TikTok Psychic, let's do a quick road so far, shall we? After the University of Idaho murders, there was 7 weeks that, I think it was about 7 weeks, 6 weeks before Bryan Kohberger was arrested. And during that period of time, the TikTok creator that we are talking about today, who I refer to as the TikTok Psychic and the Professor, one, because I know that the transcripts of these videos pull into all of the noodly googly algorithms, and I am not putting that individual's name out there in my videos or my transcripts because I do not think infamy, for those seeking to be well known on the internet, is something I want to contribute to. I have opinions about this case. So during the period of time, particularly before Bryan Kohberger was arrested, this creator was weaving fan fiction on social media regarding a professor from the University of Idaho and alleging that that professor had committed these murders and then had hired these murders and then was having an affair with one of these students. And then that's why she hired the murders, to have the affair covered up. And she doubled, tripled, quadrupled down, all the way down. She said that that was based on her intuition, her claircognizance, her psychic ability, and her tarot cards. Now, I have no problem with any of those things. I do have a problem with accusing people of murder with no evidence. That is defamation per se. You want to do tarot cards? Fine, do tarot cards. Enjoy your tarot cards. Do your oracle cards. Love it all. However, you cannot say, well, because it says so, I can make accusations of homicide. And it caused a significant amount of harassment, threats, and more to befall the professor. And again, this was continuing to spiral on social media and gain quite a lot of traction, as I have started calling it speculation spackle, in that uncomfortable bit of this horrific crime happening and no one knowing who had done it. There were many trying to fill in the gaps. This was egregious because it was just blatant, horrific, defamatory statements and a whole story being woven around it that people believed. And it got to the point that the professor was getting death threats, amongst other things, and sent a cease and desist. Well, TikTok creator being a TikTok creator, took those cease and desists, turned them into content, likened them to toilet paper, and was like, I'm not going to stop. I said what I said. I believe what I believe. You did what you did. Those things are not facts. The professor was left with no other option but to sue, decided to sue, and filed the lawsuit in federal court in Idaho And I keep having to pull up the original complaint because I forget how long this has been going on because it hurts my head. The original complaint, I'll just pull this up real quick. The original complaint was filed on December 21st, 2022. But Emily, surely the creator, oh, I can't change scenes. Surely the creator stopped after Brian Koberger was arrested. No. But surely the TikToker stopped after Brian Koberger pled guilty. No. But no. The TikToker decided to represent themselves in federal court. And it went to trial in federal court. And the TikToker represented themselves. At one point, I believe it was this attorney that referred to the TikToker as creating a clout circus. I believe that is where this is the lawsuit that came from. In the amount of time going forward, the TikToker had a bunch of procedural issues, failed to respond, had a default judgment. The court overturned the default judgment. The TikTok creator tried to get the case thrown out, tried to get the judge thrown off the case. It was filing after filing after filing after filing. And it delayed this case substantially to the cost of the professor who was paying her legal fees. This went to summary judgment, and we're going to talk more about summary judgment in the podcast this week, but this went to summary judgment motion. Different than a motion to dismiss, summary judgment looks at the evidence. Motion to dismiss, like a standard 12b6, early on in the case, looks at the four corners of the document. Is what you have alleged in the document, if everything you say here is true, do you have a cause of action? We talked about that in food court recently. Like, if everything you say here is true, is there a case? And in some of the food court cases, we have seen that that's not true. Particularly that Velveeta one, where the judge was literally like, GFO. You're mad because Velveeta's Instant Max says ready in 3 minutes, but you need to microwave it for 3 minutes. So you have to pour water in it. So it's not really ready in 3 minutes. Get out. You have not been harmed by the 5 seconds it takes you to pour water into get out. That is a motion to dismiss four corners of the document. A summary judgment motion is based on all the discovery. After discovery happens, summary judgment, there were times when I was still a research attorney that summary judgment motions would come in banker boxes of exhibits. And the judge is sorting through the case to see if there was any factual dispute that needs to go to the jury. And in civil cases, on summary judgment, you can have cases substantially pared down, completely thrown out, determined on the merits, and more. So summary judgment looks at all the evidence to find if there are any genuine disputes of fact. Could the jury look at everything that everyone's saying and say, could be A, could be B? The judge at summary judgment said there is no dispute of fact. You said what you said. What you said is defamation, period. So the case on liability ended at summary judgment. So what's left, Emily? Why did it go to trial? It went to trial on damages. How much damage, as we quantify it in an amount of money, did you cause? So, when we got to trial, it was just supposed to be about damages, and the judge had allowed for punitive damages. Those are the punishment ones. Those are the you suck damages. Like, hey, don't do this. Like, we as a jury in this community think that sucks. This behavior sucks. Don't do that. And so the judge had allowed for punitive damages in this case, which will factor in as we get further along. So it goes to trial just regarding damages. The defamation has already been decided, no genuine dispute of fact. In fact, the defendant was like, no, I said what I said. It's true. And the judge is like, I was on almost every single one of these hearings and then couldn't make it to trial. I'm so glad that Atuzzi went to the trial, and I'm so glad that there was actually someone who had been following this case in the courtroom. But I was on almost every single hearing for this case. And repeatedly, the judge was unendingly patient and asking the TikTok creator, okay, based on what objective fact? My clear cognizance. No, not just no. What objective facts? And the TikToker just kept going in a circle of, well, because I said so. And because I said so, I believed so. So because I said so, because I believe so, because I said so, because I said so, because I said so, because I said so. And the judge is like, oh, we know you said, based on what? And then the TikToker actually filed documents, do you guys remember this? In the Kohberger case to try to get sealed court documents before the Kohberger plea. And Judge H was like, no, girl, bye. Judge H was having none of it. So she was trying to get to the documents and then complained back to the court. This was after the motion for summary judgment, then complained back to the court. But Your Honor, the other judge wouldn't give me the documents. How can I prove that my defamatory statements back in 2022 were true if they won't give me the court documents now in 2020? I think it was 4 or 5 that this was happening. But Your Honor, you have to have the evidence at the time that you're making the statements. So, when this was ramping up to go to trial, the creator again tried to have it kicked out, saying, but I don't even go here. Why am I in trial in Idaho? Because you never objected to venue. That's why you're in trial in Idaho. It's too late. That ship has sailed. And yes, there could have been a fight over form, but there wasn't. We saw that in the Tati Westbrook case in Washington way back in the day. We saw quite a fight over whether Washington was the correct place. And these fights will continue going on because, you know, in the realm of international shoe and other cases about who has jurisdiction and what jurisdiction is appropriate, minimum contacts with the form, online stuff has kind of skewed that because someone sitting anywhere in the world with an internet connection and a microphone can say something that impacts you in Idaho. But do they have enough contacts with Idaho to be pulled into Idaho to go to trial? Or do you have to go to them and essentially bring the fight to them in their form? She never fought it. There was a fight there, but she didn't fight it. So, as this is getting ready to go to trial, other creators are letting me know that she is out of the country. And then I am on the call getting ready for trial, and she's telling the judge that she needs an order on her latest, you know, smoke screen motions because she's in Thailand. I honestly didn't think she was going to show up for trial. I'm still kind of surprised she did. Truly, I'm still kind of surprised she did. She showed up. She traveled from Thailand to Idaho to go to trial in Boise and went to trial over 3 days in Boise, representing herself on the issue of damages. However, she still does not seem to perceive that the trial was only about damages and not just about actual damages, but also about punitive damages. Because it seems that she was continuing to litigate, and this happened in the pretrial motions, that she was continuing to litigate whether or not she was right in the things that she said and whether or not she was correct. So there was a misperception of what the issue was. And I have been sent, and maybe one day I will summarize, because what I don't want to do is send views their direction. Maybe before we talk about this again, I'll summarize some of the things she has continued to say on social media. But she has continued to talk about this on social media and say that the jurors are idiots, that they're biased, that they are impacting her First Amendment rights to free speech and freedom of religion. She said that a lot with the judge too, that the judge was impacting her freedom of religion. Your freedom of religion is not what's meant by tarot readings not being evidence in court. That's not what that's for. So there was then a lot of but it's my First Amendment right, but it's my freedom of religion, but this is my religious practice. I am being persecuted because clairvoyant, claircognizant, psychic, etc. So this just continued on and on and on and on and on until trial, and even during trial. Goes to trial, the jury comes back. We're going to look at that. But yes, she represented herself. I will list some of Atuzzi's videos down below where he talks about being in the courtroom with her. Remember, in a civil trial, like we saw in the Afro Man trial, the plaintiff who is suing can call the defendant as a witness. So the plaintiff called the defendant as a witness so that the former federal prosecutor, Attorney Olson, got to call the TikTok reader to the stand and question her. But then, in cross-examination, she asked herself questions. She asked herself questions. She called herself as a witness and asked herself questions, like in a Q&A format. She also had the opportunity to cross-examine the professor. And this is one of the things that frustrates me, that I understand, but still frustrates me, is that there are individuals who will take the opportunity to cross-examine the person that they are going after because that is part of their calculus on representing themselves. I don't think that that is 100% the case here, like it is with Darrell Brooks. I think a huge part, and this is purely my speculation based on experience, I think a huge part of Darrell Brooks representing himself is that he wanted to cross-examine his ex, who he has a child with, because that whole thing started as a domestic violence incident that was interrupted between the two of them, and he wanted to cross-examine her. That's really common, where people want to cross-examine their victims. There are similarities here, but I think a large part of her representing herself is that she does not have the money to hire a lawyer, and she does not want to hear a lawyer say, girl, this isn't going to be good for you. I think this was much more, I'm going to stand on what I said and I'm representing myself because the truth is on my side. I think it's more that than continued harassment. It is a problem, though, when people represent themselves, that they get to stand face to face and ask that person questions and ask all the other witnesses questions. And she had the ability to do that with every witness that the professor called, which also makes court very uncomfortable. And the thing is, here's where it backfires. The jurors see it. The jurors see the pattern continue to play out. So when we're dealing with a case that is essentially internet harassment, the jurors can see it. They can feel it in court. And they, I think, did here. They came back with a pretty quick verdict. And so we're going to look at the verdict filings the filings after the verdict, and the new case. We're going to look at all those things today. So that is a broad summary, but she represented herself in trial and lost. She's upset, it seems, with how that went. She thinks the jury was unfair. She got to voir dire the jurors. You have an amount of peremptories. You can use them. That's what that's for. So let's take a look at the more recent filings that we haven't gone through yet. We're going to take a look at the verdict. No spoilers on the verdict. We have some law nerds who are new to this case. And so we're going to get to it pretty quickly, but thank you for no spoilers. Thank you for no spoilers. We're going to go through the special verdict form, but we are going to go through the trial minute orders. I'm going to need more lip gloss for this. Grab a drink, grab a snack. I need more lip gloss. I need more lip gloss. Let's go through the day-by-day orders of trial. I think that will be helpful. These are provided by the court, so we just get an overview, and then we'll go to the other filings. I think that makes sense. Let's go through trial day by day in minute order. We're gonna swoop. Oh, you know what we didn't do? We're not gonna swoop. We didn't fly to Idaho. How rude! We didn't get our miles. Yeah, I got distracted by my cookie. It is so big. It is the biggest cookie that has ever existed. I got distracted. Sorry. It's a really good cookie. Let's fly to Idaho. Or not, because it just won't play. All right, well, that's fun. I don't know why that is crashing. Miguelina, do you mind putting that in Slack? Because it will not. There we go. Wait, we had it. Where'd it go? Come back. Won't play all the way. Huzzah! We made it. Let's get to the docket. Why is today? Today, it just is. All right, this is the docket from February 24th, 2026. Well, we were in Utah. I know, we had turbulence. We had a delayed boarding. Extra snacks. There are cookies on the flight. So we will also have the gluten-free chocolate chip ones because they are excellent. February 24th, 2026. Professor is Rebecca Schofield. TikToker is TikToker, if we must, AG. Trial day 1. This is the breakdown. God, we love federal court. Total time, 6 hours, 42 minutes. Court ran from 8:36 to 8:51, from 9:01 to 11:09, from 11:18 to 11:33, from 11:44 to 12:11, from 1:14 to 2:57, and from 3:11 to 5:05 p.m. Look at federal court being all precise. Because there were time limits for this, of course. Emily, you're not going to put that in your mouth while you're talking this much. You're just not. 8:36 a.m. to 12:11 p.m. jury selection. The judge welcomed the prospective jurors, explained jury service, introduced the parties, and summarized the case. All jurors in the courtroom were sworn. Voir dire of prospective jurors. Jurors excused for cause. Each of counsel executed peremptory challenges and passed the jury for cause. What does that mean? Every time they say each of counsel, they mean Attorney Olson and TikToker. So TikToker exercised peremptories and then passed for cause. You accepted the jury. The jury was accepted. That is it. The jury was sworn to try the case at issue. The preliminary jury instructions were read, and then they admonished the jury to be back after lunch. Jury trial day 1. Plaintiff witnesses. The professor took the stand. Plaintiff exhibits 19 through 40, or 19, 20, 21, etc. 1:14 p.m. the jury is present. Opening statements made by counsel and pro se defendant. And then the professor takes the stand. So opening statements, professor takes the stand. They put in their exhibits, no objections to the exhibits, they're admitted. At 3:11 p.m., they continued the testimony, which means they probably took a 10-minute bathroom break. There were exhibits offered. There were objections. The objections were overruled, except for one that was taken under advisement. And then the judge admonished the jury for the evening. At 4:52, the jury was not present. The court and parties discussed the remaining trial schedule, the jury instructions, the objections to exhibits. The court denied the objection of the defendant, TikToker, or denied the objection of defendant's exhibits. So it sounds like denied the professor's objection to 506, 508, 509, 510 for reasons stated on the record. Defendant to file her jury instructions by 8 p.m. tonight. Yeah. The jury trial will resume the next day at 8:30 a.m. I am very tempted. To get the transcripts of this entire trial. I think I'm just going to. I really want to read the opening statements. I'm not over it. I really want to read the opening statements. I think I will probably just get the transcript because, you know, we can't watch it. We might as well just grab it. All of you are like, yes. This is the chat right now. Chat right now is 100%. Where did it go? I rearranged the new soundboard.
Do it.
I'm easily persuaded, especially when I'm like, I'm leaning in this direction and chat's like, yes, it's like decision made. All right. Let's pull up the next day. That was day 1 of trial. Let's pull up day 2 of trial. Where did day 2 of trial go? That was day 1. Here's day 2. Let's just plop day 2 in there. I wish I could just turn that off. Hold on, let me move. I need to move a different screen around. I think that will yeet my document. There we go. Day 2, February 26, 2026. Oh, this is day 3. Wait, where'd day 2 go? This is day 4. Am I missing one? This is day 1. Maybe I am. It looks like I do not have day 2 saved in my file. Let me look one other place and see if I accidentally put it in the wrong file. No. All right, chat, we're going to go grab it real quick. Give me a second. We're just going to go grab it off the docket before we get to day 3. Because at this point we're here. We live here today. So we're just going to go grab it. Let me just pull up the docket. Why is this also just, come on, Pacer, let's go. Can we just log in? Emily, what's Pacer? It is the federal court system that has the dockets for all the different courts. So that's what I'm logging into right now. And then I'm going to pull up this case from my saved cases, which is just going to take me a second to do because, well, I regularly max out the amount of saved cases you can have because there's a lot of cases that I've got an eye on. Some of them are stuff we haven't checked in on in a minute, but that's okay. All right, let's grab, who knows, maybe there will be something new on the docket today. There's new filings from yesterday. Yeah, we have yesterday's filings. Let me find day 2 of trial. That's docket 141. So we should be, docket 140 is what we're looking for. I got it somewhere, but not saved. All right. Let's just grab docket 140 real quick. Save that. I know, I hate doing this in real time. This is why we prep, but some days that goes better than others. Today is one of those days. Emily, you're going to start singing Limp Bizkit, probably. All right, but I'm here with the Law Nerds, so it's a good day. Trial day 2. I can't scooch this over anymore because I do not have it in my program, but we'll just embiggen. It will be fine. Emily fights with technology. There we go. It's all going to be fine. Trial day 2, total time 5 hours and 59 minutes. Emily, did each side have an amount of time? Yes, each side got a specific amount of time. They did not get, they got an equal amount of time. So the court was keeping time the way we saw in like Depp Heard. I just keep picturing the court with like a chess counter, but the court kept time for sure. Jury trial day 2, plaintiff witness, Rebecca Schofield, TikToker, Kim and Sean. The plaintiff exhibits, the defense exhibits, 8 a.m. The court addresses preliminary matters. 8:35, the jury is present. There we go. That's a little bit better. 8:35, the jury is present. Continued testimony of the plaintiff. The defendant's exhibit 519 is offered. The objection's overruled. Plaintiff's exhibit 34 is offered and admitted without objection. The testimony of the professor ends. 10:04 a.m. The plaintiff calls the defendant and then does a direct examination. These are all of the exhibits that were offered. Emily, why so many exhibits? Well, guess what those exhibits are, y'all? The TikTok videos. Those are the TikTok videos. Those are 100% all of the different TikTok videos. How would that testimony have gone in court? Is this you? Did you say this? Is this you? Did you say this? Is this you? Did you say this? Did you have any evidence? Did you have anything to back that up? My tarot card readings. Okay, is this you? Did you say this? Over and over and over again. So yeah, the surrealness of sitting in court as a juror and just watching somebody say awful things on TikTok and knowing that they're defamatory because the judge already ruled that they're defamatory. So they go through the plaintiff's exhibit, defendant's exhibit. 518 is offered and admitted without objection. 512 is offered. So the defendant has a couple exhibits that are offered, I imagine, during the defendant's cross-examination of themselves. At 1:57 p.m., the plaintiff called their next witness, Kim Rytter, R-Y-T-T-E-R. More exhibits were offered. Then they got into other testimony. At 2:31, the jury was dismissed. At 3:11 p.m., jury instructions were discussed, and the jury trial was set to resume on the 26th at 8:30 a.m. So that is our next in order of trial day 3 that we did already have pulled up. All right, trial day 3, let's go. Trial day 3. Trial began at 8:30 a.m., 6 hours and 3 minutes of trial ending at 3:20. Trial day 3. Plaintiff called the Rebeccas. If you watched the pretrial motions, the expert witnesses were all named Rebecca. We joked, I think Lyndon started the joke of calling them the Tribeccas. But there it was like a triforce of Rebeccas that testified. So the Rebeccas, Christopher Hansen, John Carlson, I think, and then Margie Schofield, the mother of the plaintiff. Plaintiff exhibits, defense exhibits. We saw the testimony happening. Outside the jury's presence, the parties discussed taking judicial notice of Koberger's indictment, plea agreement, and judgment. And they did that, and the jury was told about that. The testimony continued. The court and the parties took up a matter outside the presence of the jury and the public. Defendant made motion. Court recessed to consider defendant's motion. Plaintiff withdrew opposition to motion. Court granted the motion. I wonder if that was... I'm going to just look at the docket and see if I can get any sense for what that might have been. Let me take a look. Yeah, let me take a look real quick because I'm actually really curious what that motion could have been related to. And I wonder if there's a further docket note on it. This is just purely my own side questing curiosity. Because we're in the realm of docket 141. Oh, it is on the docket. I feel like we should side quest. Yeah, I feel like we should side quest. We're definitely going to side quest. We're definitely going to side quest. All right, let me grab that. I don't think I have this exhibit either. Let me just double check and see if I do before I download it again. I don't. I don't have. How did I miss this one? I'm so disappointed in myself. It just didn't even. Oh, you know what? I bet it was sealed. I bet this was sealed outside the presence of the jury and the public. I bet this was sealed and then unsealed after the final judgment was entered. All right, let me download that because I can see from the title that we are going to need to explore what this is. So Emily, today is a side quest day. Oh, 100% today is a side quest day. Today is a deep dive side quest into I don't even know what. All right, let's finish reading day 3, and then we're going to get into this motion that has been, I think this was probably sealed, and that's why I didn't grab it, because if I'd seen the title of it, I would have grabbed it. We know that the jury was instructed that Kohberger pled to the murders. We know that there was a recess to consider defendant's motion. The jury was back. The plaintiff's witness took the stand. That was the plaintiff's mother. Attorney Olson presented the stipulated facts regarding Brian Kohberger to the jury. I probably would have asked the judge to do that, but I don't think it really matters. And the jury is allowed to be aware of that. The judge admonished the jury for the evening, which is like, don't do any research, whatever. Outside the presence of the jury, the court and parties discussed final jury instructions. Plaintiff objected to the special verdict form. Court overruled the objection. Defendant had no objections to the special verdict form. The jury trial will resume. The court did not just disregard everything that the TikToker did in court. There are a number of times in the docket that we're seeing that the TikToker won their objections and won their motions in court. There are times that the plaintiff is objecting to things that are overruled. It was not just completely one-sided, as I think the TikToker is now arguing that it is. There are times in this that the court agreed with the TikToker, and we've seen that. All right, let's grab this new docket item. Let me just put it where it needs to go so I can grab it easily. And we're going to side quest real quick on, well, what I presume was sealed before now. Is that the right one? That does not look like the right one. Where's the other one? Hold on. It's now hiding from me. Emily, we have too many things going on. Yes, it's a lot of dockets. It's a lot of documents, keeping up with as many dockets as we do. But the law nerds have granted the motion for EDB side quest. So, where are we? Side quest it is. Side quest it is. Docket 142, filed February 27th. So this, I imagine, is the written version of what was orally discussed outside the presence of the public and the jurors. So let's grab that. Defendant's motion to excuse juror 13 for cause. All right, let's take a look. If she was psychic, she should have been able to foresee the issue with the juror. How did we not see this coming? Comes now. TikToker, who respectfully moves the court to excuse juror 13 for good cause. This is seemingly in the middle of trial. Due to extreme bias, misconduct, and the inability to be impartial. This has to happen before you seat the jury, unless something new happened. TikToker says, first, Juror 13 expressed the inability to be impartial due to her Catholic religion. If that's true, the judge would have excused her for cause. She stated she is Catholic and against witchcraft. Ma'am, you brought multiple motions arguing that the court was interfering with your freedom of religion. And yet you want to kick a juror off the jury because they're Catholic? Okay. The juror stated, this is all according to TikToker. Oh, we're going to need the transcript. We're going to need the transcript. The juror stated that she is Catholic and against witchcraft. Again, this is according to the TikToker, who I personally do not find to be a reliable narrator. So just caution that. Stated she's Catholic and against witchcraft, indirectly calling defendant a witch. She's a witch! Okay. Okay. You cannot remove a juror for their religion or their race or their sexual orientation or identity or their disability. Ma'am? Chad, I don't know if she's made of wood. I don't know. Tracy, I think you have very generously, Tracy in the chat said maybe she thinks Catholics don't believe in psychics. I think you have very generously put rational thought behind the knee-jerk response we're seeing here, which is she believes that this juror is not going to have an open mind because of the allegations here. Yeah. Yep. Yeah. I don't think anyone got turned into a newt, so I think it should be fine, right? So the defendant believes that the juror indirectly called her a witch. This creates a strong bias against defendant because of her spiritual practice and beliefs. Second, Juror 13 has been communicating with the plaintiff through body language since being selected as a juror. This was already a very, very worthwhile side quest. The juror is alleged to have been communicating via body language to the plaintiff since being selected. On day one of trial, she's going to tell us how. On day one of trial, Juror 13 looked at the plaintiff and shook her head in affirmation after being selected as a juror. How do you shake your head in affirmation? I'm also shaking my head in quandary. The following days, Juror 13 looks to Schofield when she enters court, seeking agreement through body language. Oh, fucking hell. The court has been clear that jurors do not have contact with the parties while outside the courtroom. You mean the jurors look at the parties when they walk in for the day? The type of contact they're talking about is like, hypothetically, say an attorney is waiting outside the courtroom doors for the courtroom to open because they are very stressed about being late to court because this particular judge gets really feisty when this attorney, just hypothetically, is not punctual for court because, lost time is never found, Miss Baker. Emily, is this a hypothetical? Sure. Yes, it's still a hypothetical. Lost time. But there was a kerfuffle, and so we weren't allowed to be in the back hallways. So the lawyers in this hypothetical had to wait in the public hallway outside the main doors of the courtroom. And the jurors are very timely. So when the attorneys are waiting outside the courtroom and the jurors have been told that they can't have any contact with the attorneys, the type of contact the court is worried about is a juror, hypothetically, walking up to an attorney in the middle of a trial and saying, I think you're an incredible woman. That is not permitted. That type of contact. That's the type of contact that we're talking about. Because then that attorney, hypothetically, would have to walk into court and look at the judge and be like, so, we're going to have to address a juror communication in the hallway. And then the defense attorney trying not to laugh, snort through their nose because they watched the whole thing happen. And then you have to bring in the juror, hypothetically, of course, and ask them questions about their statements in the hallway and why they made them and what happens then. And then because there are other jurors present, each juror in the middle of the trial has to be questioned by the judge about whether they heard the other juror telling the prosecutor that she is an incredible woman and then asking her out in the middle of the trial. And then each juror has to come in while the defense attorney is sitting there being like, this is amazing. And then just perhaps every time that prosecutor is in court with that defense attorney, the defense attorney would be like, good morning, incredible woman. Like, good morning. Good to see you. Yeah, good to see you. And no, this is not the same defendant that yelled in arraignment court about me and a different defense attorney. No, different instance. Court's wild. We haven't even gotten through all the stories of court. That was a different instance. So, the defense attorney giggled about it every time we were in court together. Because honestly, I would too. On a different trial, the foreperson of our trial had the common sense to wait till after the trial to ask out the defense attorney that I was in trial with. And she and I would joke about it frequently. And the jokes would go something like, the audacity. She's like, they convicted my client in like 17 minutes. And then is going to come up to me and be like, hey, you want to go out sometime? No, I just lost. I don't want to go out with, get the fuck out of here. No. Hypothetically, of course. I very much enjoy that attorney, but different case. Emily, this happens? Yes. I've been asked out by defendants. I've been asked out by jurors. I have a friend who had a juror reach out to them after the trial and ask them out, and they're married with multiple children. Who knew? However, when you're a trial attorney, you don't get to leave work that often. So, I mean, I guess it is a way to meet people during voir dire. It's just like, but no, it's not this. It's not this. It's not this. This is not the type of contact. Crochet Cat Mom said it's a whole soap opera in court, isn't it? You could make a Grey's Anatomy styled show about it. Yeah, you could. Mm-hmm. And base them on real stories. Either way, I'm going to put a pin in that story for later. There's a story we're going to put a pin in for later, but that's the type of contact they're talking about. They're talking about jurors having conversations with the lawyers. This will come up even if a juror says to a lawyer, good morning. What'd you get? What coffee you got there? It's a problem. They are not talking about looking over at the parties and walking in. That's not what we're talking about. On day 1 of trial, Juror 13 looked at Schofield and shook her head in agreement. Did she ask her for a date? No. The following days, Juror 13 looks to Schofield when she enters the court, seeking agreement through body language. The court has been clear that jurors do not have contact. There shouldn't be a space there. This should also include body language that suggests agreement or bias inside the courtroom. Ma'am, no. Third, Juror 13 also admitted having prior knowledge of TikTokers' videos. For these reasons, TikToker moves the court to remove Juror 13 for cause immediately. That's not how this works. That's not how this works. This motion is supported by the attached memorandum in support. Oh, good, there's a memorandum in support. Great. This isn't how this works. Defendant's memorandum in support of motion to excuse Juror 13 for cause. Jurors must be fair and impartial. If a juror allows religious prejudice to influence their verdict, it constitutes misconduct, as they are required to base decisions solely on evidence and law. Generally, expressing religious beliefs does not inherently establish that a juror cannot fulfill their duty. That's accurate. That is correct. Also, it's a protected class. You can't kick people based on their religion. But what they say, you can. This should have been done during voir dire. Voir dire. However you want to pronounce it. This should have been done then. Juror 13 expressed that being Catholic prevents her ability to be fair and impartial. I don't think she said that in that way. She also referred to TikTokers' spiritual practice as witchcraft, used as a negative connotation expressing disdain and bias towards TikTokers' spiritual beliefs. Juror 13 then stated at the request of the court that she can base decisions solely on evidence and law. TikToker goes on to say, however, her actions in the court, using body language throughout the trial to affirm or suggest agreeance with the plaintiff, suggest 13 cannot be fair and impartial. We have seen most of this stated above. So, Jay, for goodness sakes, says, anyone else hearing I have cause? It's because I hate him. Yes. All right. She also referred to TikTokers' tarot readings and spiritual practices. Witchcraft, I already read that. The plaintiff argued in favor of keeping Juror 13. The court allowed Juror 13 to affirm that she could be impartial and decided not to excuse her for cause. Okay, then you can. This is what peremptory challenges are for. A peremptory challenge based on, I don't think this juror can treat me fairly based on the things they've said, is exactly what a preempt is for. The judge denied the motion for cause, preempt, yeet. That's what your peremptories are for. You have to use them strategically. Why didn't you just use a peremptory? It's literally what they're for. So, Juror 13 was selected as a juror and trial commenced. Her argument looks like a rehashing of the above. They say that the juror expressed bias. I still don't know why you didn't exercise a peremptory. I'm going to need a transcript. We're going to need a deep dive. Stated that she can set that knowledge aside and be impartial. I mean, this is about damages. This witness is, or this juror is not deciding if what you said was defamatory or not. They're just deciding damages. If a party feels that a juror is biased against them and the judge doesn't kick them for cause, they have a method to also kick them. Let's see. The juror claimed she already knew details about the case from TikTok and pretrial publicity. She stated that she can set that aside. However, during jury selection, the TikToker says that Juror 13 made an impartial statement that TikToker practices witchcraft. This also implies that she had a preconceived negative opinion that TikToker is a witch. I am not trying to downplay bias against a party. Bias against a party is a problem. There was a mechanism to address that problem. And then we get into the body language. The TikToker goes on to say that although Juror 13 changed her mind and stated she could be impartial, her actions in court have proved that she continues to act with negative intentions, bias, and prejudice towards TikToker because TikToker uses tarot cards, oracle cards, and believes in esoteric spirituality. Ma'am, let me introduce you to Catholic communion, says the girl who grew up Catholic. Can we talk about communion, ma'am? If we're talking about esoteric spirituality, I have a conversation I would like to have with you about Catholicism and all of the rituals, all of the symbolism, all of the dates that are based off of the astrological calendar. I would like to have a conversation. Okay, sure. Can we talk about the holy water? Samantha says, EDB, no, they hate us already. I will let it go. It's just an interesting argument. She just thinks TikToker thinks that this juror doesn't like her. Sometimes jurors don't vibe with you. I had a juror stink face me an entire trial. And the judge wouldn't let me use a peremptory. That's a whole nother thing. I've ranted about this before. My jury hung 11-1. Guess who the one was? I wasn't wrong. However, I was stuck. But that doesn't seem to be the case here. Apparently, the juror head nodded to the plaintiff implies she has the intent to help or align an agreement with the professor without hearing all the evidence in the case and without considering the laws. Nonverbal positive contact between professor and juror 13 has continued since the first contact. She comes in, makes eye contact with plaintiff, and reaffirms her. This is highly inappropriate. Against the rules that requires jurors are fair, impartial, and based decisions on the evidence, law, and the facts. Well, that's why you have a lot of jurors. Juror 13's religious bias against TikToker and move to align with the plaintiff without hearing all the evidence is a violation of the defendant's rights. The defendant asks to yeet said juror. That is my summary. And then it looks like she also made a declaration. I mean, you could just pull a transcript. Her declaration is, I observed these things. Okay. I'm back to, I'm going to need a transcript to see how peremptories were issued. I have so many questions about this. Let me take a look at the docket real quick and see if there's anything else, because that must have been sealed prior to me grabbing all these. Otherwise, I would have grabbed it when I grabbed day 4. Let me see if there is a Further note from court, I do not see one. Let's just go and see if it's addressed on jury trial day 4 in the jury trial day 4 notes, because that seems like the place it would be. And let's see. Wait, why is this being weird? Don't be weird. There we go. Don't be weird. Okay. Trial day 4. Docket 143. 3 hours and 57 minutes of court time starting at 8:29 a.m. The defense witnesses are TikToker, defense exhibits, plaintiff's exhibits. 8:29 a.m. Outside the presence of the jury, the court took up defendant's motion to disqualify Juror 13. Plaintiff objected. The court denied the motion as stated for the record. I imagine the record went like, you could have used a peremptory. 8:40, court questioned jurors. Juror 13 advised court information appeared on social media. No! What? TikToker is trying to excuse Juror 13. The court denies it. They get in there in the morning and the judge is like, same 3 questions. I don't think that's the exact language the judge used. Same 3 questions. And Juror 13 is like, well, actually. I need the transcript. Well, actually. Oh my God. So we get to Juror 13. Excuse me, Your Honor. I saw some shit on social media. All the jurors were excused and Juror 13 was questioned. Can you imagine? The plaintiff's attorney must have been like, for fuck's sake. There. Oh my goodness. Juror 13 advised the court that information appeared on social media. Jurors excused and Juror 13 questioned. Plaintiff rests. That juror stayed though. Plaintiff rests. Jurors present at 8:49. Defendant testifies on her own behalf. She did it through question and answer. What is your name? Name. What do you do? I make TikTok videos. This is not a direct recreation. We're going to need a transcript for that. If y'all are interested, and it seems that you are, these are all the defendant's exhibitees, some of the plaintiff exhibitees. Defendant rests, 11:20 a.m., jurors present, jurors advised of post-proof jury instructions, parties presented closing arguments. 12:30, court gave final jury instructions, plaintiff placed or bailiff placed under oath, jurors excused to deliberate. Court advised parties that the jurors had reached a verdict. 2:47 p.m., jurors present. Juror 15, 4-person verdict read, jurors excused at 2:56. 10 minutes in and out. So it doesn't say who the alternates were. I'm not sure who the alternates were. There would have been alternates. I'm not sure who. Let's see if it says anything else on the... We're just going to go back to the docket, back and forth. But I don't see... anything else on the docket about that. But alternates... They had alternates. They had at least one alternate. Either way. Chat's like, at least it wasn't number 13 that was the 4-person. Facts. So let's go to the verdict, shall we? We're going to look at the special verdict form, and then we are going to look at the entry of judgment, and then we are going to look at the post-verdict motions. So let's get into the special verdict form. The defendant didn't have any objections to this. Plaintiff did. This is docket number 146, filed February 27th, special verdict form. Question number 1. Do you find by a preponderance of the evidence that defendant's false statements that plaintiff... See, when I tell you they had already decided defamation, it's in the verdict form. Do you find that the defamatory false statement that plaintiff had an inappropriate romantic relationship with a student damaged plaintiff. Did this, there's two defamatory statements. Did this defamatory statement damage plaintiff? Yes. State the amount of compensatory compensation damages, $1 million. Question 3, do you find by clear and convincing evidence, two different standards, do you find by clear and convincing evidence that defendant's false statements that plaintiff had an inappropriate romantic relationship with a student warrant punitive damages? Those are the punishment ones. Yes. How much? $2.5 million. Continuing on. Question 5. Do you find by a preponderance of the evidence that defendant's false statements that plaintiff orchestrated the murder of 4 students at the University of Idaho damaged plaintiffs? Yes. State the amount of compensatory damages, $1.5 million. Do you find by clear and convincing evidence that defendant's false statements warrant punitive damages? Yes. How much? $5 million. $10 million total. It is possibly the largest individual defamation verdict that I have seen. It is, well, the way that the verdict or the way that the statutory cap worked in Depp Heard lowered the verdict amount below this for Depp Heard, $10 million. Emily, are they ever going to collect on this? Probably. Maybe not all of it, but some of it, and we'll talk about why in a minute. Because there is room here for garnishment. And pretty easy room for garnishment. So, we'll talk about that. I don't know if they'll get all 10 million, but they'll be able to garnish forever. $10 million. $10 million where the jury is like, no, unacceptable. So then, Katrin said Idaho doesn't have a cap. Idaho does have a cap. The amount of the cap for treble is treble damages essentially in Idaho, so triple compensatory. So when you look at the compensatory and triple it, you end up right on the button at 10 million. So they took the compensatory damages and kept this right at the cap. So this falls exactly on the line. There was a lawyer on the jury. We know there was a lawyer on the jury because people keep talking about it, but there was a lawyer on the jury. So yeah, this hit the cap. This was every moment, every penny that they could award. They awarded every single penny that they could justify. Endless says, can they still garnish if she's living in Thailand? Yes, because the person who is paying her is the United States government. So yes, they can garnish it because the money is coming from here that they can garnish. And I do not think she has a work visa abroad where she could earn money abroad. So we'll talk about it. $10 million. But plaintiff had another motion to make. Oh, actually, let's look at the final entry of judgment just for the pure satisfaction of the entry of judgment, because, you know, entry of judgment. There it is. There's the official entry of judgment. We said 2026 was going to be the find out. This is the fucking find out. Docket 149. Judgment is hereby entered in favor of plaintiff against defendant TikToker for all claims contained in plaintiff's first amended complaint. Defendant shall pay plaintiff $2.5 million in compensatory damages, $7.5 in punitive damages. Done. And you got the really pretty seal on it. Done. I agree. Teaspoon of Splenda in the chat said, unfortunately, 10 million still can't undo the damages. No. Money is not going to fix it. Money is an indication. Here's what the 10 million does from my perspective. 10 million grabs enough headlines that it starts to undo all of the search engine stories connecting the professor's name to something she did not do. 10 million now overwhelms the stories. And so if you're looking for the professor's name, the allegations aren't going to come up first. The fact that she won this massive judgment is going to come up first. So it does start to undo some of that damage because it will at least be a signal online that what was said about her was wrong. And so wrong that a jury sent a massive message. And when it comes to punitive damages, that's exactly what a jury is allowed to do. Punitive damages are find out. They are meant to be punishment. They are meant to be knock this shit off. This is unacceptable in our society. This is not how you comport yourself. And hopefully this amount of money will check you to knock it off. Now, there are plaintiffs who feel, or defendants that feel that they are judgment proof, and they will continue to wild out, which is difficult. But it is a signal that this will not be tolerated. And it is meant to not just send a signal to the direct defendant, and that is allowed and appropriate. It is meant to send a signal that this shit is unacceptable. And if you want to fuck around, you're going to find out. That's the signal it sends. Knock it off, is what it says. Cindy in the chat said, I thought lawyers aren't allowed to serve on juries. Lawyers can serve on juries in the US. I don't know if that's different abroad. Lawyers can serve on juries. There are some restrictions to that, depending, but a lot of times they don't because other lawyers are like, nope, go. Like, you never know where a lawyer's perception is of the burdens or where they're going to fall on clear and convincing versus a juror who's not an attorney. So you never know. But yeah, lawyers can absolutely serve on jurors or juries. When I was working at the DA's office, I would have other DAs from my office appear in the jury pool. They can't sit on my case. We work for the same office. There is a conflict of interest there, and that's not proper. But I also worked in a building that had city attorneys in it that were not connected to the County of Los Angeles. A LA County DA could go sit on a civil case or a city attorney criminal case. Now, would a criminal defense attorney want a prosecutor on their jury? No. It would be like off. But they could go sit on a federal grand jury case or a civil case or something like that. A lot of times the lawyers don't want other lawyers watching their work. But I had one time a lawyer on my jury, and I will never do it again. I did not need that level of feedback. I didn't like the pen color you used when you were writing your instructions, and your handwriting kind of goes up. I'm like, I am dyslexic and ADHD, and I have no phonemic awareness, and I have no mind's eye. And I am trying to handwrite something because early 2000s, I am trying to handwrite something, and I am pit sweating that I am going to spell it wrong and embarrass myself. And I am in closing arguments, and your feedback is that you don't like the color of my pen. Cool story, bro. And never again did I leave a lawyer on my jury. Never again. Never again. Never again. That was it. $10 million. $10 million. $10 million. Let's continue. I know. It was, I agree with the audacity. I was just like, thanks. Thanks for the feedback. What color was the pen though? Orange. It was an orange pen. I felt red was too aggressive. Orange stood out. And then when I used other colors to modify things, because then I would put the evidence in green. So I used orange to write the jury instructions. And then I would use green to write the evidence that went to that jury instruction. And it worked well together. Like it was easy to see both. It worked well for me. I loved it. But they didn't vibe with it. There's more filings. So after the final judgment, the plaintiff filed another motion. This is the professor. The professor, they weren't gel pens, they were markers. Because I needed the jury to be able to see it. And I didn't like using the Elmo. I liked organically being, it also gave me something to do with my hands. I liked organically being able to write the key parts of the jury instruction and then work through it like we were all working through a problem on a whiteboard together or a blackboard. What I loved about some of the trials that I did is that the jury rooms actually had dry erase boards that they could write on. And I saw jurors working through things in deliberations the same way I worked through things in closing. And I was like, I feel so validated that I've helped you. Like I've shown you a process to work through this decision-making process. And then you were able to take that process and work through it. I appreciated it. Plaintiff has a filing because we're not done yet. We're not done yet. What we've learned is that nothing really ends at the verdict. The verdict is a jumping off point for the rest of the litigation. We're just jumping off for negotiations. It's never quite done. This is docket number 151 from March 19th. Plaintiff's motion for attorney's fees. Plaintiff, by and through her counsel, submits this motion for attorney's fees. Let's go through what that motion asks for. Having prevailed on summary judgment on her defamation claims and having been awarded $10 million in compensatory and punitive damages, plaintiff seeks her reasonable attorney's fees in the amount of $163,719.10 under FRCP 54D and Idaho Rule of Civil Procedure 54E and Idaho Code 12-121. Plaintiff's request is based on the records and files in this matter and the affidavit of attorney. That's actually less than I would have expected, truly. Federal Rules of Civil Procedure, or FRCP, 54D2B, provides that a motion for attorney's fees must be filed no later than 14 days after the entry of judgment and must specify the judgment and the statute, rule, and grounds. In diversity jurisdiction cases, substantive state law on attorney's fees applies and then cites the law for that. Under Idaho law, a court may award attorney fees to the prevailing party if provided for by any statute or contract. A trial court's determination of the prevailing party is within the court's discretion. Well, it's real clear who prevailed. I don't think, is there anyone that thinks that there was not a very clear prevailing party? Idaho Code 12-121 provides that, quote, in any civil action, the judge may award reasonable attorney's fees to the prevailing party or parties when the judge finds that the case was brought, pursued, or defended frivolously, unreasonably, or without foundation. Well, that seems to just ding, ding, ding. That seems to just pin the tail on the donkey right there. That just it's a nail on the head. Other analogy puts the ball through the hoop. Whatever analogy you want to use. Under this standard, the court looks at whether the losing party's position is so plainly fallacious. Fallacious? No, wrong. Emily, what word are we thinking of? No, fallacious? Damn it. Hold on. Emily, your mind is inaudible. I know. We're going to have to go. I'm going to get this wrong. We're just going to go to the pronunciation guide. Emily, do you live by the pronunciation? I have no phonemic awareness. I live for the pronunciation guys.
Fallacious.
Oh, I was right.
Fallacious.
The moments when you question yourself and then you're correct. My mind went somewhere else.
Fallacious.
There we go. Fallacious. I was correct. I love a judge with a super sense of humor. I know it's too spicy adjacent. It's too spicy adjacent for me. Oh boy. Okay. So plainly fallacious. That's our word of the day. So plainly fallacious as to be deemed frivolous, unreasonable, or without foundation. Love a word of the day. All right. Fallacious. There we go. The pronunciation guide at dictionary.com said it with enthusiasm. The motion goes on to say whether an action was brought, pursued, or defended frivolously, unreasonably, or without foundation is a matter within the broad discretion of the court. Yeah. What do you think the court's going to do here? The court encouraged settlement discussions multiple times. And the TikToker was like, nah, we doing this. Also, the TikToker's statements post-trial could play into this because she's not done wilding out. The court should award the professor her attorney fees and costs. They have asked for the TikToker to be sanctioned at least twice. At least one time, of which I was like, do it, Your Honor.
Do it.
Where is it? Hold on. I will get this. I will get this down, but it was.
Respect my authority.
I was ready for the judge to throw the hammer down on some sanctions more than once in this case. And the judge was incredibly patient. And I was like, no.
Liar!
Nope, wrong one. That one's new. That was wrong. I meant that one. I mean, it works.
Liar!
It works. Emily, what is that? Khloe Kardashian. That's Khloe Kardashian. That's how I hear it in my head. It works. So there were times in this case where the court withheld sanctions. I think sanctions are appropriate. I think that attorney's fees are appropriate. The professor goes on to say that TikToker defended the case frivolously, unreasonably, and without foundation, that the actions repeatedly increased the cost of litigation. The TikToker, and this is true, the TikToker brought frivolous counterclaims, repeatedly challenged the court's jurisdiction, failed to meet deadlines, brought last-minute motions, including that motion to continue. Like, Your Honor, I just need more time. She repeatedly testified and admitted that her false statements lacked any basis. In fact, accordingly, an award of attorney's fees is appropriate. I'm not even going to read the section that talks about the professor being the prevailing party. $10 million judgment. They go through the code. They talk about the increased cost. As an initial matter, Professor filed this action only because TikToker refused to stop making and posting TikTok videos with false statements about her in response to 2 cease and desist letters sent through counsel. TikToker acknowledged receiving those letters and made disparaging TikToks about them. The docket is likewise replete with TikToker's actions that delayed the litigation and increased cost. She initially failed to file an answer within the time limit. The clerk's default was entered. Then she filed an answer, counterclaim, and request for relief. The court allowed her late filed answer. The court ultimately granted the motion to dismiss the counterclaims, including patently frivolous counterclaims against the lawyer. Yeah, that happened. Although TikToker consented to have this case heard by this court, once the court ruled against her, she repeatedly challenged the decisions, sought reconsideration, filed objections, and sought to have a different judge, including an Article 3 district court judge, be assigned to the matter. Each of those motions not only required the professor to incur additional attorney's fees and costs to oppose the motion, but they delayed the ultimate resolution of the case. Indeed, it took 5 months for the district court to resolve and deny the motion for reassignment, which was an inappropriate motion to do. She was kicked off TikTok. She's back on TikTok. I don't know how it's not a ban evasion. She's back on TikTok. It has been sent to me. It seems like ban evasion for me, but she is back on TikTok. I wouldn't suggest going to watch it because it will give her money that she will try to abscond with. And I definitely wouldn't give her attention. Yeah. I'm sure there's a YouTube channel somewhere where they take like her videos and put them up on somebody else's YouTube channel that's not connected to her. But yeah, no, there is TikTok. I don't think it's appropriate, but there is. All right. 5 months to resolve the ridiculous motion that should never have been brought and a lawyer would never have brought. TikToker also routinely declined to participate in a joint settlement conference. Facilitate scheduling or take any other steps towards the resolution of the case short of trial. She failed to meet pretrial filing deadlines. In October 2025, while she was in Thailand and other locations outside of the US, she engaged in a last-ditch effort to delay or deny the long-awaited trial on damages by filing a third motion to dismiss for lack of diversity jurisdiction. Ms. Kensington, did diversity jurisdiction exist in this case? Right. On the eve of trial. And the judge was like buffering about it. Just buffering about it. The professor was required to expend additional attorney fees to respond on a shortened time period in light of the trial date just over 2 weeks away. TikToker's litigation positions throughout the proceedings were frivolous. As the court noted in its memorandum decision in order granting the professor's motion for summary judgment as to liability, TikToker has no evidence to show her statements were true, and that the evidence put forward by the professor highlighted, quote, the complete lack of any corroborating support for defendant's statements. TikToker doubled down on the lack of corroboration of her false statements. She asserted that no facts were necessary, just her intuition. She literally ipsy-dixited it, but she doesn't know what ipsy-dixit means. But literally because I said so, because I say so. Because I say so. She asserted that no facts were necessary, just her intuition. Moreover, she used the litigation to repeat her false and defamatory statements about the professor in her pleadings. Literally all the time. And then she's going to quote them. Quote, Professor planned, initiated, ordered, and executed the murder of 4 University of Idaho students who were killed in Moscow, Idaho on November 13th, 2022. Quote, Professor has not proven by a preponderance of the evidence that she did not order the murder of 4 students, nor has she produced any evidence that she did not have an affair with the victim. Quote, the tarot card and oracle card readings on Plaintiff professor, who was listed as the chair and associate professor of the U of Idaho History Department, revealed that she planned the murders and made a choice between two male students to execute the murders. It also revealed that she had a secret affair with one of the victims, and her motive to have the students killed was to silence them and keep her secret affair from being exposed. She picked a face off a website and was like, this person. Quote, during what she coined a quote unquote spiritual investigation, TikToker discerned that the students were murdered due to a targeted hit ordered by a history teacher, professor, and executed by the ex-boyfriend of the victim. The motive was to murder victim KG before she left Idaho to prevent the exposure of an affair between the professor and the victim. Quote, during what she coined a spiritual investigation, remember she was a spiritual witness. During what she coined a spiritual investigation, TikToker discerned that the students were murdered due to a targeted hit. It repeats that in a different filing, same thing. TikToker also discerned intricate details. By discern, she mean made up. Intricate details of the events that occurred the night of the murders. TikToker published the findings to her TikTok channel. She also used the litigation to falsely accuse the professor of harassing her. We're down an earring. She also used, I lost my place. Where was I? There. She also used the litigation to falsely accuse the professor of harassing her, fabricating testimony, she's still doing that, and damages. To stop TikToker's information from being taken seriously and to silence the professor and her attorneys, and the witnesses, she says that other individuals filed a lawsuit against her with 2 frivolous claims for defamation. Oh, no, that was TikToker. This is written in a difficult way to file. The TikToker filed frivolous claims against the lawyers to try to silence them. And then this is TikToker saying that professor initiated the lawsuit with full knowledge that she was responsible for the death of the full students with the intent to harass, embarrass, humiliate, and discredit TikToker. TikToker says that the professor filed the lawsuit to embarrass and humiliate and discredit her. Plaintiff, let's see, I'm going to change the size of this one more time because it moved. This goes on. We're not done here. I like Attorney Olson. Attorney Olson's like, no stone left unturned. No stone left unturned. TikToker also said that the plaintiff, through her legal counsel, listed legal counsel, worked concertedly to silence the defendant. They sent demand letters. We demand you cease and desist. We are giving you the opportunity to not find out. Please stop fucking around. They sent demand letters, filed frivolous civil actions in federal court, defamed the defendant. This is all stuff the defendant has said. Defamed the defendant in the news media and used their community connections to harass the defendant on social media. No. This is, again, more filings from defendant. Quote, it is reasonable to determine that the plaintiff and the alleged experts intentionally fabricated their testimonies to manipulate the court and the jury to help plaintiff fraudulently obtain jurisdiction. Additionally, this is TikToker saying this, plaintiff, along with her experts, fabricated witness testimony, medical records, and evidence. It goes on. In short, through her pleadings, TikToker used this litigation to further harass and defame the professor. That TikToker is a pro se litigant is no excuse. No, she took it as an opportunity, I think. Pro se litigants, whatever their ability level, are subject to the same requirements as other litigants. Yeah, you should have asked your lawyer. TikToker's litigation records shows that she defended the case frivolously, unreasonably, and in a manner that increased the professor's cost of litigation. The fees are reasonable. I think the fees are low. I think they'll be lucky to get it paid, but I think the fees are low. The lawyer in this case spent 118.7 hours of labor on this case. I'm surprised by that. The associate spent 194 hours. The paralegal, the associate and the paralegal picked up the rest of the time. The paralegal spent 112.7 hours on the case. There's a footnote to that. They contemporaneously kept timesheets in 6-minute increments reflecting the work done. A chart containing those timesheets is attached. So I think the fees are much lower than I expected for this case. Much lower. And I wonder if they also gave the professor a discounted rate. Even if they gave the professor a discounted rate in their motion for attorney's fees, they can seek reasonable attorney's fees, even if it's more than what they had agreed upon. That I don't think is what's happening here. These fees are low. I'm surprised. I think in a different jurisdiction, this would have been multiple hundreds of thousands of dollars more. And then they go on to justify their attorney's fees. I think their attorney's fees are low. I think they're more than justified. $160,000 for a federal trial, including all the pre-trial litigation BS. I think that is reasonable. They billed at $400 an hour. There it is. Attorney Olson billed $400 per hour, well below her regular rates. Look, Attorney Olson could say, my rate for this work is this, bill it to plaintiff. That would be acceptable. She's not doing it here, probably because it's going to make it even harder to pay, but this is incredibly reasonable. Attorney Olson billed her work at $400 per hour, well below her regular rates. The other attorney also billed at $400 per hour, also an amount that did not increase over 3 years plus 3 years of litigation. That is a senior associate and experienced litigator. He's a graduate from the University of Michigan, clerked for federal judges at the district court and court of appeals level, and worked at the office of the attorney general for the state of Idaho before joining the firm. Ms. Bibb, the paralegal, billed her time between $300 and $315 an hour, has significant expertise in reviewing, analyzing, and capturing social media posts. The amount of time to capture all of these social media posts in a way that you can use them in court would have taken time. And then they go on to continue to set forth the legal foundation for attorney's fees. I already agree. And I also think that the rate is low. I think that there would be justification to ask for more. Let's see. So they're going through the rest of it to justify their attorney's fees. That's their request for attorney's fees. And then all the billable rates, they're asking for $163,000 and a little bit more. That is low. I think there's grounds for it. I think the court can order it. They have not ruled on this yet. We have not seen an opposition filed by the TikToker yet. But that's just the motion for attorney's fees. Chat, what else do lawyers have in addition to attorney's fees? What else? What else are there? Yep. Costs. Comes now the plaintiff's motion for costs. So let's take a look at that. Yes, also coffee. Also coffee, but costs. So plaintiff, after the $10 million verdict and judgment, the plaintiff is asking for attorney's fees at a reduced rate of $163,000 plus. Hear me when I say that if you expect to do 3 years of litigation in a federal trial and pay $160,000, it is not realistic. This is a compassionate attorney that cared about this case and reduced their rate in this case for this plaintiff. I love a firm that's got a level of because fuck you, that's why. We saw that with Alessi. And some firms can. Because fighting someone who has a fee waiver and is representing themselves, which means when they file, they're not even paying like $300 to file a pleading or whatever. They have a fee waiver. So they're just, the thing that it costs them is time. Because everything just gets emailed in. And they continue to rack up the costs. So $163,000 is incredibly low for how much litigation this case was. That is not oh, you could pursue a defamation case. No. 500,000 or up. Nope. Continuing on with costs. Plaintiff's motion for cost. We're just going to look at this in a little more of a broad way because they can be awarded costs. They are the prevailing party. I think the record supports that this was defended frivolously. I am shocked at that amount. Professor respectfully requests the court award $1,700 in costs, $1,722.61. That's it for costs. Also, reasonable. That is so low. Let's see. The costs are so low. I wonder if the experts did not charge for their time. That would be reasonable in this case. On June 28th, plaintiff incurred charges of $276 for a transcript of the summary judgment hearing. On December 21st, the plaintiff incurred charges of $402 for filing the complaint. And then travel expenses for the experts, meals for the experts that seem to be incredibly low. No hotel bills are in here. Incurred an expense of $381.81 for round trip airfare. Everybody was like, no, just book it as cheap as you can, which is generous because there are some experts that would never. $381.81 in airfare, $22 for meals, $30 for taxi, $297 for a hotel. So $700 for expert travel and meals. What is that? It's one meal? They didn't even that's not even an airport snack. It's so low. Then again, they were only traveling from Pullman to Moscow. The statutory witness fee limit reimbursement of the travel and hotel expenses and mileage. The total round trip miles between Boise and Moscow is 574 miles at the statutory rate of 1.78 per mile. The reimbursement is $1,021.72. Thus, Professor is seeking costs of $1,021.72 for the travel. So that is a low request for cost. Some of the witness fees are in there, but yeah, $1,700 total. No, it's reduced. No, there's 17. Okay, there's two. 1,700 on one page, a little over 1,000 on the other. Low. Low amount of fees. But again, they're going to be in a position where the concern becomes how do you recover these fees? And that's a very real issue here. However, these judgments can stick around forever. There is punitive damages here. There is the potential, of course, that the TikToker will try to make money in some other way and they can go after it then. But I think what they want is the TikToker to stop. I think that's always what they've wanted. And they're probably going to have to seek an injunction to get that to stop. Because otherwise I don't see it stopping. And that can become very difficult. Is what do you do next? There's a $10 million judgment out there, but if the other party sees it as monopoly money, what do you do? I mean, it helps with the headlines, but you're still not done litigating this. And we know they're not done litigating this because April 6th, we've got a new filing from the TikToker.
Emotional damage.
So, we haven't even gotten to the other lawsuit yet. So, the TikToker has filed their motion for relief of judgment due to fraud.
Liar!
Mm-hmm. Do I have more on my soundboard? I don't know if I have more on my soundboard.
Survey says.
Nope. Not today, Judge.
I have an entire soundboard and nothing quite gets us there. Defendant's motion for relief of judgment due to fraud. Comes now TikToker and moves the court for a relief of final judgment due to fraud. The plaintiff lied about having damages, presented false evidence in court to the judge and jury, filed fabricated medical records, falsely portraying as damages related to this case. And, excuse me, I can't even say the words because my throat's like, you can't speak bullshit into existence. The universe is like, it's so ridiculous, you actually aren't going to be able to talk. Okay, deep breaths. The allegation are false medical records, false damages, false witnesses, lied under oath. For these reasons, the entire case is fraudulent and a violation of the defendant's rights to a fair trial in federal and state proceedings, guaranteed by due process and the 5th and 14th Amendments. As a result, TikToker moves for relief of judgment. All right, chat. I grant your motion for Code Green because the audacity of this shit. Like, this, again, this is just going to increase the cost of litigation after taking the L. Did we ever think that the professor was going to take the L and move on, or the TikToker was going to take the L and move on? Because, right? They should take her fee waiver away. Just take away the fee waiver. Make her pay the filing fee for all of this shit. I bet the calculus would go a bit differently. I bet it would. When you have to start paying for it, I bet the decision making goes a bit differently. But we're going to take a look, because there are times when we look at cases and there are times when we see things on the internet and we go, why doesn't somebody just this? This is why. Why doesn't somebody just sue? This was filed in 2022. This is part of why people choose to not. This is why. So yes, Code Green is granted. The audacity of it all. Let us go. My lights didn't want to go green in time. We're green now. Hopefully it doesn't throw off the white balance too much. Now we're green. Elizabeth asked, what happens if the TikToker declares bankruptcy? Does this judgment for damages go away? Not necessarily. How much was the professor awarded? $10 million to start. I think there's more, but $10 million to start. So the $10 million judgment is not dissuading anyone, it seems. But did we think that was going to happen? Like, when you look at everything that's happened in this case, I keep going, well, maybe someone will just see reason. No, they're not. No. This is locked in on their position, and they are never going to see this differently because they believe that they have been wronged by everything. Ask your guides, ma'am. It's not the jury that wronged you. It's you. This is self-inflicted damage. Continuing on. Let's see what fresh fuckery is in this motion, shall we? TikToker's memorandum in support of Rule 60B3 motion for relief of judgment due to fraud. The memorandum in support provides supporting arguments and evidence that the professor and the attorney committed several acts of fraud by presenting fabricated evidence under oath, misrepresenting medical records as evidence. They were admitted as evidence. They were admitted as evidence. Ergo, evidence. Misrepresented medical records as evidence. They say that Professor lied under oath during witness testimony several times and presented witnesses that also lied under oath. Federal Rule of Civil Procedure 60B3 allows a court to relieve a party from a final judgment, order, or proceeding due to fraud, misrepresentation, or misconduct by an opposing party. I have seen misconduct, but it's not as you portray it to be. This rule covers various forms of dishonesty by an opposing party, including misrepresentation, hiding evidence, fabricating evidence, and lying under oath, perjury. A motion based on fraud under Rule 60B3 must be made no more than 1 year after the entry of the judgment or order. Well, it is timely. So there's that. Defendant filed this motion within 30 days of judgment. TikToker shows by clear and convincing evidence, saying the words doesn't make it true. It's not bippity boppity, standard of proof, that the fraud or misconduct occurred and that it prevented TikToker from having a fair trial in a proper jurisdiction. And here we go again. Background. On November 13th, 2022, 4 University of Idaho students were murdered near campus in Moscow, Idaho. With no arrests at the time, on November 22nd, 2022, a community member asked TikToker to conduct tarot readings on the murders to get information on who killed the students and why. I'm sorry, you guys, it's my bad. It's my bad. I forgot that if someone asks you a question and you answer it, it's TikTok immunity. My bad. They asked me a question and I answered. Therefore, I did nothing wrong. That's not how it works. A community member asked. I didn't just decide to do this on my own. Someone on TikTok said, why don't you answer this question? Okay. Okay. TikTok privilege, right? I had forgotten. TikTok privilege happened way earlier ago in this case. It is totally my bad. My bad. Back to TikTok privilege. Someone on TikTok asked her to do tarot readings. And what was she to do, chat? They asked. I had to answer because they asked. By November 23rd, the very next day, TikToker began conducting tarot and oracle card readings. Parenthesis readings. I don't even know. On who, what, when, where, and why the murders occurred. This is not how this works. But this is how she says it works. She discovered through the the readings, that one of the students had a relationship with the plaintiff. The message of the readings also revealed that professor ordered the murder of the 4 students. TikToker received 2 demand letters to cease and desist content regarding the professor and to retract her statements on December 12th. TikToker responded on social media that she did not have to cease and desist her content because she is telling the truth and protected by the substantial truth doctrine of the First Amendment of the Constitution. Nope. Not correct. On December 21st, plaintiff filed a complaint with 2 claims. It says assault, libel, and slander. There's no assault. I think, if Grok was helping with this, they got that wrong. That's not there. Complaint with 2 claims was filed on December 21st, 2022. On February 17th, the professor filed a motion for default judgment. The motion for default judgment sought at least $1,863,304, alleging that the false statements caused professor promotions, leadership capabilities, and salary increases at the university to be jeopardized. Oh no, okay, and the way she phrased the sentence, that's fine. I'm just already annoyed. It's fine. Professor alleged that TikToker 1 jeopardized her publication of book manuscripts, book chapters, and articles that were pending review. Right, because that happened. 2, jeopardized the ability to collaborate with co-authors. Right, because now you are, in fact, tainted by the scandal. 3, limited the professor's ability to perform new studies and new work regarding LGBTQ populations. Right, because you were accusing her of having a same-sex affair with a student. Same-sex affair, fine. Affair with student, not fine. In fact, highly inappropriate. Can't do that. Don't do that. Can't do that. Caused Schofield severe mental distress due to receiving hate mail from anti-education groups who oppose her work on the LGBTQ community at the university. On April 26, 2023, the court denied the motion for default judgment. The court gave the TikToker another chance. On January 12, 2024, Professor filed a motion for partial summary judgment and a motion for leave to amend the complaint to add punitive damages. The court granted the motions. Hey, she's gotten better at reciting the case. The recitation of the case is better. I mean, it's kind of ripped from what the judge has done, but the recitation of the case is improving. So there's that. The court granted the motions. On March 15th, the TikToker filed a motion for reconsideration based on newly received evidence. That's based on stuff that was happening in Idaho. The court denied the motion. On February 24th, 2026 to February 27th, a jury trial was held on damages only. Oh, so you understand that it's on damages only. Despite not having any evidence to support it, the jury rendered a verdict of $2.5 million in compensatory damages and $7.5 million in punitive damages. That's argument, not a recitation of the facts. Legal standard, I don't know if I want to get worse at law by reading this. She states that the legal standard for a Rule 60B motion must be made in a reasonable time. That's been done. She cites no other standard. She just recites the language of the code section or of the FRCP section. And then she argues. So this is not an actual statement of legal standard. Her argument is it's illegal to intentionally lie about damages in court, as this constitutes perjury if done under oath, or fraudulent misrepresentation in civil proceedings. I'm not going to comment on that because I am not trying to help. Providing false information regarding injuries, damages, or financial losses can lead to severe criminal and civil penalties. In Idaho, a party damaged by perjury in a civil case can sue for damages such as fraud. Oh God. Are we now foreshadowing what's next? That was all argument. That was all argument. That was argument. That was argument. And now more argument. TikToker goes on to say that the professor's complaint is founded upon the foundational lie that she was damaged. Just because you don't agree doesn't mean it's not true. The jury heard the evidence and decided that it was true. Online harassment can harm people. The reason that defamation is a cause of action is because there are times that words said can cause such reputational damage that it needs to be accounted for, and dueling is no longer a thing. We have decided that there needs to be a less murdery way to deal with disputes. So, because we're not grabbing, pistols and Weehawken, we're here. This is how reputational disputes are solved. So, it is acknowledged by the law that damage to reputation causes harm. The things that were said caused harm. If this TikToker had said, no, that, hey, what if there was something more going on here? No names, no putting a picture up on a screen and then not saying a name. I don't want to help anyone sidestep defamation. There are ways to have a conversation about a thing that are not defamatory. Accusing someone of being a murderer is not the way. That's not the way. And that's why we're here with a $10 million verdict. She goes on to say, I know, Thrusty86 said the 10 dual commandments are no longer useful. I know. There are some parts that are useful. Try to get everybody to work it out. They tried to do that. Here, it's a settlement conference. You don't have your second, try to resolve the dispute. But settlement conference is essentially that. You have your lawyers, essentially your second. You have your lawyers try to resolve it. And then somebody goes, nah, we're doing this. And then you end up in trial. There are some parts of it still helpful. So, Lyndon, I completely agree. Lyndon said this is one of the most clear-cut examples of defamation that could exist. Yes. Accusing someone of murder is just defamation per se, period. Just, yes. Accusing people of crimes. This goes on to say that The professor falsely claimed to have damages exceeding $75,000. The court has already addressed that in the past. Schofield falsely claimed to have at least $1.8 million in damages, alleging that the TikToker's false statements caused promotion's leadership capabilities and salary increases to be jeopardized. Anyone who's worked in academia is going, that's exactly what happens. Scandal isn't it. It absolutely caught. And then the fact that it took from 2022 to now to resolve, it is still going to take time. It is still going to take time, even though she won. It goes on to say that the professor continued to lie about professional damages. I disagree. Filing documents of her attempt to continue to lie about having 10 years professional financial damages through the expert testimony of Dr. Rebecca. That's why an expert comes in. A jury can disbelieve an expert or not. It's up to the jury. The court accepted professor's damages as true, and its decision and orders were all influenced by the foundational false claims of damages. That assertion is not factually based, because that is not what the court did, except in circumstances when the court was required to take the pleadings on the four corners of the document as true for motion practice. She should ask her lawyer about that. Your lawyer will understand that better. The TikToker goes on to allege, Emily, she's pro se. I know that's the part of it. She goes on to say, additionally, and don't ask like ChatGPT, it'll just tell you that you're right even when you're wrong. So that's not going to, just being gassed up is not going to help at this point. Additionally, the TikToker alleges that the jury were also influenced by the foundational false claims of damages as reflected by the verdict for $2.5 million in compensatory damages that do not exist. The jury says it exists. She goes on to say that without the false evidence, false documents, and blatant lies, perjurious testimony of witnesses, she doesn't have a valid case. I'm sorry. So let's distill this into reality. Without her testimony and documents and evidence, there is no case. Correct. Without testimony, documents, and evidence, and filings, there is no case. I agree with that. I can agree with that. However, there is documents, testimony, and, evidence. Wait, where is it?
Receipts, proof, timeline, screenshots, everything.
Right. Case. She goes on to say that the professor lied under oath and presented false evidence for professional damages. Everyone, go ahead and laugh in academia. During the trial, we're going to go with Sean Q, the dean of the College of Letters, Arts, and Social Sciences. Can you imagine? Can you imagine for a moment needing to have the dean of the college that you work in come and testify in a defamation trial for you? I'm sorry to all of you that just had a panic attack. Can you fucking imagine having to go to your university and say, hey, I'm so sorry for the harassment the university is getting, because people were blowing up the phones and the emails of the entire university because of this. And people were blowing up the phones and the emails and everything of the university because we know how the internet's, I wish it didn't, but it does. before Kohberger's arrested. So the community is shaken by a brutal murder of 4 students. And then you have someone on social media making it all fucking worse by preying on fear. And then pointing that fear and frustration at the university and at the history department. And then the professor is in the middle of a tornado, not of her own doing in any way. All this plaintiff had the audacity to have a job where her face was on the university website. That's what the professor did. The professor had a job at the University of Idaho and was targeted because of that. And then have to go to work and be like, so hey, all this shit is happening online. And we have to have like department meetings about safety. And we have to deal with the calls that are coming in. And we have to get campus police and probably state police and possibly also, well, probably also
The FBI!
involved. The students are scared and grieving. And now they're having to deal with all of the logistics of online threats. And the university is having to deal with the logistics of online threats. And this is all happening prior to Kohberger ever being arrested. It created an absolute shit show, for lack of a clout circus, because the TikToker hated that phrase, for clicks and views and to prey on people who were scared and looking for answers. And while I would hope most people would see something like that and just be like, well, that's some bullshit, many don't, especially when they're scared. Our brains do weird things when we're afraid. And it's just appalling, truly. And then to still come in here and just be like, this is all bullshit. It's appalling, and it's why I keep covering it. Because the initial headlines were all about the allegations against the professor, and there were so many of them. And then they died down. But there were so many appalling headlines. And a lot of media outlets that just are like, oh, some person said this on TikTok. Wow, look at that. Headline. And then when she sued, it was, oh, she's suing TikToker. Headline. And then coverage, not much coverage outside of social media platforms until it started trial, which is why the professor had to go to trial. Because otherwise, how do you undo it? Which is why we're going to keep covering it, because there is a cost to this that is hard to see if you're not watching it happen year over year. And those of you that are just seeing this case for the first time, welcome. Is Emily always this pissed off about cases? No. But sometimes. But for those of you that started watching coverage of this in 2022, 2023, some of you were like, wait, is this still going on? Right. Because while we're all looking at other stuff and going on and living our lives, they are still, particularly the professor, because the TikToker seems to be like, yeah, whatever. The professor is still dealing with the fallout and is going to continue to deal with the fallout. And if you've ever been in litigation, you're kind of always waiting for the other shoe to drop. So is living with the stress of pending litigation for years. Yeah, that has a cost. Online harassment has a cost. And the TikToker is just saying all of it's false. All of it's lies. So let's see. How did we get on this tangent? Well, because the dean of the college had to come in and testify. And all of you are just like, I would die. I would crawl into a hole. Right. This is not easy. The dean testified that he is the professor's boss, that he testified that professor did not lose any job opportunities nor promotions. I want to see a transcript. He testified that he did not believe the statements about the professor's involvement. Well, right. It doesn't matter if the dean does. The dean can support the professor. It doesn't mean she's going to be up for authorship opportunities. The dean said that the professor continued to receive satisfactory job ratings, was promoted, and received pay increases several times. What's the rest of the testimony, though? Like, what is the rest of the testimony, though? The TikToker goes on to say that the professor's lies about financial professional damages over $1 million throughout the litigation and during the trial were perjurous. I press X to doubt. She goes on to say that the attempt to procure the expert witness testimony of Rebecca Talent, Tallent, to fabricate 100 years of professional damages to Schofield's career was subornation of perjury and fraud. There were actually there was filings regarding the scope of the expert's testimony, and it was limited because of that. During the trial, Kim Rytter, Rytter, the general counsel and chief compliance officer for the university, testified as a witness called by the professor and testified that Schofield was not investigated. You're telling me that the University of Idaho police did not investigate the professor? Okay. Because I would imagine that she had meetings with
The FBI!
and Moscow PD and others. Okay, medical bills. The professor testified under oath that she received nerve damage in her legs due to a TikTok video. Again, I don't believe the filings. I'm just going to need the transcripts. We will see what the other side responds to because the professor's going to have to respond to this. Because I imagine that that's not the entirety of it. Schofield testified under oath that she received nerve damage in her legs due to the TikTok video. I imagine that there's more to that, right? She also filed those medical records as evidence and presented them to the jury. I mean, did the professor end up with like stress-induced shingles or something? I can imagine a lot of circumstances where that might be valid, but not in the way it's presented here. The TikToker goes on to say there's no medical evidence to support that she can get nerve damage from a TikTok video. You are building a bit of a straw man argument here. This is not in any way what I think happened in trial. She goes on to say that the CDC, according to the CDC, diabetic nerve damage or diabetic neuropathy is a common complication caused by chronically high blood sugar. What does that have to do with anything? Oh, she continues that the professor's mother testified that the professor had been diagnosed with diabetes, a fact that Schofield admitted from her testimony. Are we talking about like gestational diabetes? Also, if the stress caused worsens an existing condition, that's fair. We're just, yep. We're going to need transcripts. The TikToker has now substituted her own medical knowledge, saying, quote, "It's far more likely that the professor's doctor connected her alleged nerve damage to her diagnosis rather than a TikTok video. Instead, she says the professor lied under oath in witness testimony that she got nerve damage from the TikTok videos." I imagine stress was the underlying factor here, but don't worry, the TikToker is also a doctor. I'm being facetious. TikToker's not a doctor. She goes on to say the professor also fraudulently filed her medical records and bills as evidence. Ma'am, if you objected and then the court overruled it, it means it's evidence. The other witness, Rebecca Bond, is being accused of lying under oath. You're right. Diana in the chat said her degree was spiritually obtained. You're right. That is my bad. Just like TikTok privilege, one can just become a doctor based on vibes. Like, no, I Googled it. Totally the same. She goes on to say that the court deemed Rebecca Bond as an eligible expert witness. Therefore, according to the court, that witness is competent and responsible for her statements under oath. That's not what that means, but all right. To justify Schofield's mental health damages and claims of PTSD, the professor called Rebecca B as a witness. During her testimony, Rebecca B, the TikToker says, lied under oath several times. We've seen this in multiple motions. I hate even giving it breath. The TikToker says that the testimony does not comport with the DSM-5 and that she does not believe that something somebody says online can be an appropriate underlying cause of PTSD. I am not giving this any more debate or air. She has made these claims multiple times. Her treating professional testified. The jury gets to decide. In closing statements, I'm very interested in this. Their arguments, by the way. In closing arguments, Attorney Olson asked the jury to discriminate against TikToker. Oh, girl. Did the TikToker call her own mental health expert? No, she testified herself as all the witnesses. In closing, she says statements, attorney asked the jury to discriminate against the TikToker. Let's hear the argument on this one, shall we? During closing argument, there it says argument on that one. Great. I don't know why there's a discrepancy between the heading and the first sentence, but continuing on. During her closing arguments, Attorney Olson asked the jury to punish TikToker on behalf, period, of all quote unquote psychics for our spiritual beliefs because, quote, we can say anything if we believe it. I'm going to need the entire transcript, but I imagine most would say, we don't claim her. This isn't how you do it. So Okay, I'm going to need the transcript. The jury followed her request by punishing TikToker with $7.5 million in punitive damages without any evidence that TikToker made an intentional false statement with malicious intent. The jury does not have to determine if there's defamation. We're back to not intentionally. Not intentionally. Ma'am, do a reading on how well that worked for Sarah Boone. She goes on to say that, in fact, TikToker presented evidence that she did not make any statements about the professor with ill intent or knowledge of its falsity. Her argument is like, I believe it. I believe it. I believe, sure. I believe in a thing called love. Sure. This is a ma'am, this is a Wendy's. This is a damages trial. It's a damages trial. I guess she's saying that should mitigate the damages. Not intentionally. The jury probably likes it less, though. She goes on to make the outlandish claim that it is more likely that the jury sought to punish TikToker based on her spiritual beliefs. I imagine, well, I can't wait to see what closing really said, but I can see an attorney saying, it is preposterous that someone on social media can just make up anything they want, accuse someone of crimes, and it caused this much damage. It's not hyperbole. It's not comedy. It's not exaggeration. It's not lemon pound cake. It is accusations of murder. And that is the line. That's the line. But she alleges that she was punished based on her spiritual beliefs. And yes, Chad, I agree. She has not defined her spiritual beliefs, just practices. I agree with you, but here we are. I'm not trying to help. She goes on to say that it's a direct violation of the jury instructions and due process. Yes, I also, chat, see the inconsistency of saying, well, this person can't be a juror because they're Catholic, but yes. Cheryl said she did drag the Salem witch trials into her argument. Salem wants to be left alone. Of course she did, because she sees that she believes that she's the one being persecuted. Right. I know. It's wild. I, again, am so glad that Atosi went to sit in court and watch this unravel. Because we were in the middle of Corey Richins, and the things lining up at the same time were so mad. Conclusion. It's Emily, keep reading. I was reading chat. Sorry, chat. This case appears to be a 2026 rendition of the Salem witch trials in 1692. Fucking hell. There it is. She's not done making that argument. She says that she was targeted and punished for her spiritual beliefs, and false evidence, perjurious witnesses, and fabricated damages were used to render a verdict of $10 million against her. That's not what happened. You were not targeted. You targeted someone else. If you had responded to the cease and desists, it would have stopped, but you didn't stop. You went to a website and picked someone out and targeted harassment at them and defamed them. All of those were choices and actions. Emily, we are not going to be able to reason that which is unreasonable. Yes, I know. But also to paint herself as the victim in all of this is, it's just outrageous to watch. Ma'am, there's actually a police department I would love for you to do a reading on. They're not, it's not in Idaho, but maybe we could hear me out. Maybe we could take our bad time and turn it into a good time and try to figure out what's going on in Ohio. I think maybe we need some psychic readings to figure out what's going on below the surface and figure out if that lemon pound cake ever got eaten. I think this is going to be the solve. Because then she can just go investigate what's going on over there. And then she and, the Afro Man sheriffs, they can all just take up each other's time. So maybe she could figure out what's like underlying that. Oh, and the judge too. We've got a lot of questions about the judge too. So let's start there. And then we'll go from there. I think that would actually be helpful. That'd be great. Just, I got some other suggestions after that. Emily, no. Look, maybe they could all just take up one another's time and leave the professor and Afro Man out of it. Just, I think it could be productive. Perhaps. Just a thought as we are reading through the ridiculousness that is this. Okay, so she has likened herself getting sued to being persecuted. She says that her practices were even referred to as witchcraft, that the professor filed the complaint against her even though she lacked any damages. Disagree. Therefore, she had to lie and fabricate damages to justify the court's subject matter jurisdiction. That's been litigated over and over and over again. And to receive financial compensation. Defendant TikToker respectfully motions the court for relief from the final judgment of verdict. That's going to be denied. I can see that coming. The plaintiff lied about having damages, presented false evidence in court, and filed fabricated medical records. I don't agree with any of that. And that's the end of that motion. We're not done, though. We're not done. No. Nope. Because there was another filing from her, same case, on April 6th. So where are we at? We're at a $10 million verdict. We are now, it's not even doubling down. We are now digging a trench to hell to double down with the TikToker, making a motion to set aside the entire judgment based on fraud, saying all of this is just a lie. All the witnesses are lying. The medical bills are a lie. Everything's a lie. And then she compares it to the Salem witch trials, saying that she is she is being persecuted based on fabricated and perjurious evidence. That doesn't seem to comport with what happened in court or reality, but that is the filing regarding setting aside the judgment. What does that mean? It means the professor is going to have to respond to it. But that's not all. But wait, there's more. But wait, there's more. But wait, there's more. Because on April 6th, 2026, there was one more thing filed by the TikToker, and that brings us up to date on this docket. Notice of judgment, or notice of appeal from judgment. Emily, you're so tired of the yep, I am. Notice of appeal from judgment. Court case number, date filed, date of judgment, order you are appealing, docket number you are appealing, which is docket number 149, which is the final entry of judgment that we looked at with the cool seal on it. Yeah, I redacted, because she is pro se, I redacted out the addresses, phone number, etc. Yep, notice of appeal. That has not yet hit the Ninth Circuit dockets, but she is noticing her intent to appeal. Emily, based on what? Well, I don't know. It's just here. So she is going to appeal this to the Ninth Circuit. I imagine what she is going to say is everything we have just seen her say. And maybe the Ninth Circuit will require her to pay and not have a fee waiver. Rachel said, why do people think she's in Thailand? Because she's in Thailand. She listed a Texas address. She keeps listing a Texas mailing address, but she also keeps making content in Thailand. So she is in Thailand. She keeps filming content in Thailand. That's why. She also told the court she was in Thailand. She also said she almost didn't get let back into Thailand based on content that I had seen about it. So it looks like she is going to be leaving Thailand to go to Bali because she is at the end of her visa in Thailand. So yeah, no, she is using a Texas address, but is in Thailand based on everything that we've seen. So, I will have to summarize some of the content because I do not want to send anyone to give views. I think that Marquis and Atuzi, I will pronounce it both ways, Erling, I think that they both cover some of what she says on social media. I generally don't look, but people were like, have you seen this? So, but she has a Texas mailing address. So where are we at with the, I mean, she hasn't made it to Vietnam yet. Maybe she did. I mean, there's not a criminal case here, but she did get out of the country more successfully than Donna Adelson, but there's no criminal case here. This is all civil. And the fight is not done, even though the professor won a definitive and resounding $10 million judgment against the TikToker. It still doesn't stop because she's filed notice of appeal. She's asking the court to set it aside, and the litigation cycle is just going to keep on going. But that's not the only litigation that she's involved in, because I was trying to, well, I figured she was going to appeal a $10 million judgment. I'm not going to say, Emily, rein it in. I'm not going to say any more about that, lest I give anyone ideas. We'll wait until the time period passes. But I thought that there would be an appeal given everything that we have seen, the amount of the judgment. We'll see what grounds she is appealing on. This is a very facially thin notice of appeal. More will need to be filed. I would like to not give any ideas. So I'm going to wait because I would like to not give any ideas. But with a verdict that big, one can assume an appeal is going to happen. And when I was looking to see if it was filed, because the notice of appeal wasn't on the docket yet, I was looking to see if it was filed and found another lawsuit. And I was like, what in the ever-loving is this? And so then I did a little bit of a deep dive, as much as I can, into a newer docket, because there's another case. Because the TikToker has decided to sue the IRS. Emily, you're surely joking. No, I'm not. No, I'm not. So we're going to take a look at that now. We're going to change the lights back. And we're going to take a look at the TikToker suing the IRS. Yes, we are. Yes, we are. Yes, we are. Because this seemed like a good idea, apparently. So we are going to go through this. I have redacted. I am not going to go through I'm going to go through what she has filed. I am not going to go through all of her returns. We're not going to forensically account this. But asking for the attention of the IRS is a real interesting choice. It's a real interesting choice. So we're going to look at the complaint. We are going to look at the recent orders. And we are going to look at some of the things that the TikToker is alleging. And we're going to keep an eye on this one because I am very curious as to what's going to happen. So, buckle up. Let's take a look. This is not my redacted version. Where did my redacted one go? Hold on. I have a redacted version of this. And I do not see it. Hold on. I'm just going to scroll. I confirmed, by the way, that this was the same individual by name, email address, phone number, and residence on all of the unredacted documents I have. So yeah, I can just chop the heading off of this one because I put the redacted documents up in the Laundered Lounge because when I saw this, I was like, you guys aren't going to believe this. So I shared it over in the lounge because that's where the sneaky peeks go of the y'all WTF. And thank you, all of our lounge members, for being able to go, oh, when are we going to talk about this? I'm like, it's coming. We're going to talk about it. It's coming. We're going to talk about it. Don't worry. We're going to talk about it. And yes, though I do not like all of what's going on, I am still not going to put all of the addresses and stuff up in the internet and what have you. Why? Here's why. I hope that other than us covering this by referring to platform and not individual's name, that the attention will go away. I think that this creator very much wants to see themselves as persecuted. And people going and leaving any comments is going to fuel that belief. The best thing to do is to just pull the air out of it. And so that is part of why I do not refer by name ever. I will not put images of the TikTok creator in my thumbnails. I'm not going to do it. I think that covering the case and then also trying to say what we need to do is not give attention. The attention is what is being sought. We are going to talk about what we're seeing and we are not going to give attention to the best of our ability. But anyone having, their information on the internet can cause harm like we saw to the professor. Also, I don't want anyone to go give more attention because the views will just keep it going. Because we want attention So we're spiraling out for attention. We are not going to give attention. No attention. We're going to do our best to hopefully it'll just fade away. Timely reference to today. All right. This is the complaint. Emily, it looks kind of weird. Yeah, I didn't put the notice page up. There's addresses on it that I didn't grab the redacted version from the right place. So this is the statement of claim. The United States Department of Treasury, IRS, used TikToker's race to falsely accuse her of submitting a false tax return for the year 2021. In furtherance of the false accusations of fraud and withholding of her 2021 tax refund, the IRS also withheld the 2024 tax refund. Emily, what happened between 2021 and 2024? I don't fucking know. I don't know. Maybe we'll find out. Maybe we won't. Maybe we won't. She alleges that the IRS is withholding her 2024 tax refund in the amount of $4,213 after she sent a demand letter seeking the issuance of her 2021 tax refund of $11,555. Oh, look, 555. With interest to avoid a lawsuit. Good, solid strategy. Reach out to the IRS, send a demand letter, demand money, and then demand interest, and then tell them you're going to sue them. Good. Yes. This is the approach. This is the approach. This is it. Did anyone make a TikTok video of the demand letter? Was the IRS just like, I do what I want? I do what I want. I do what I want. It's like they didn't listen to your demand letter? What is that like? I don't know. So she sent a demand letter asking for the IRS to pay her with interest to avoid being sued by her. In 2023, she says that the IRS admitted that their processes were disproportionately negatively affecting Black taxpayers. I have not seen anything about that. If that's true, I don't know if it applies here. But I don't know. Is it possible? Sure. Is that the case here? No idea. It goes on to say disproportionately doing extra reviews and audits on their accounts, withholding their tax refunds, issuing false flags of identity theft, causing them to wait months and in long lines for appointments with the IRS to verify their identity and denying them COVID credits. Okay. It goes on to say that she was negatively impacted by the systemic discrimination in 2023 and sought help from the IRS Taxpayer Advocate Services. I didn't know that they had that. Okay. Sought help from the IRS Taxpayer Advocate Services. After TikToker followed all of the instructions given by the taxpayer advocate by filing the necessary amendments. Oh, we have a filing issue. We have a filing issue. By filing the necessary amendments for 2021, correcting unintentional errors. Okay. So, amendments and errors. So we have a filing issue. We have a filing issue. We know an IRS agent. I mean, he's about to go to prison for like ever. But you could probably find his address to write to him. Brendan Banfield might have some advice. You know, he worked for the IRS. He likes big cookies. He likes big cookies. Big cookies, good. Emily, you said you weren't going to eat while you were talking. I know. They're really good, though. They're really good, though. They're soft. I know. Totally annoying. Apologies, chat. Couldn't help it. Part of the bit. So she tells the IRS that she's going to sue them. She demands a refund with interest, then talks to a taxpayer advocate who tells her to file amendments and correct errors. She said unintentional. Not intentionally. She does that in October 2024. The taxpayer advocate falsely accuses her of being part of a social media scam. Oh, no. Oh, no. Oh, no. Well, that's going to piss her off. That's not helpful. I also have questions about what was actually said. The taxpayer advocate falsely accused TikToker of being part of a social media scam. The taxpayer advocate further accused TikToker of filing a fraudulent tax return without any evidence and based the accusation solely on her race. Was it based on the return, though? After falsely accusing TikToker of fraud, the IRS and taxpayer quote, now it's a quote unquote advocate, the taxpayer advocate, threatened TikToker to remove all COVID sick leave tax credits, parentheses, authorized to self-employed individuals under the American Rescue Plan Act and the IRS fact sheet from 2022 through 2022-15 from her tax return and comply with their request, or she would have retaliatory audits on previous tax filings. I imagine that that's not how all of that happened based on everything we've seen elsewhere, because the way that she relays information seems to be less than reliable. So there may be problems with the IRS. We've covered very few of them, not including Banfield. So I don't doubt that there's problems with the IRS. You're not going to get argument from me. However, I have questions about how this conversation went down, and it is not beyond, conception that the IRS said you don't qualify for those things. You have to take them off of your taxes. I can see that happening, but we'll see. She says that the IRS is threatening her with retaliatory audits and that they are telling her to do things with her taxes that is based solely on racial discrimination per her. She goes on to say that after she sent notice of intent to sue the IRS due to discrimination in January 2025, the IRS did a retaliatory audit on her account, removed her income, removed all credits from her 2021 tax return, and assessed her a penalty of $2,311. She is now suing. I wonder if, as she is saying retaliatory audit, the IRS is saying evaluating the claims that you've brought to our attention. Because you're making a lot of allegations that the IRS is doing stuff. I imagine their response to that is to look at it and see what's happening. Not that I don't think the IRS refrains from having their curiosity piqued by certain things. I don't think they would call it retaliatory, but I'm not going to delve into that much further. However, we know that happened with Teresa Giudice early days in Real Housewives of New Jersey. They were like, that behavior seems odd. We should take a look and see what's going on there. But it sounds like the system red flagged the return already because she was already complaining about the return. So it sounds like the return was already a problem. But this started in 2025. She's in the midst of the other stuff going on in Idaho and is suing the IRS. She goes on to say that she seeks the court to order the IRS to issue her plus, it just cuts off, to issue her plus interest actual direct economic damages in the amount of $27,000. How did we get there? Excuse me, where are the damages? Direct economic damages in the amount of $27,341. Full 2024 tax and reimbursement of all court fees and attorney fees. July 17th, 2025. I wonder if they're going to try to garnish her taxes. Curious. So the court made an order in February that we're going to take a look at now. Emily, are we letting this go? Oh, no. Oh, no, I have a lot of questions. You know that Emily goes to follow the money first. I am very curious where we are going with the money, or is there legitimate impropriety within the IRS that is going to be uncovered by this case? I'm curious. We're going to have to find out. Who knows? I'm not making up my mind. But something flagged that. And then she said, I'm going to sue you. And they went, we're going to just take a look. Curious. This is from February 18th, 2026. This is an order from the United States Court of Federal Claims. Chat, I know that your burning question is, Emily, what font is that? I don't know, but I love it. It is very constitutional. It's vibey. I like it. But the IRS, look, when dealing with the IRS, here's what we need to remember.
Don't be suspicious. Don't be suspicious. Don't be suspicious. Don't be suspicious.
Look, man. Don't be suspicious. Because the IRS is going to be like, that's weird. What are we doing? Here we go. Order. On December 31st, 2025, the government filed a motion to dismiss under Rule 12b-1 and a motion for a more definitive statement under Rule 12e. So what happened? The feds said, excuse me, What? Can you please explain? What the fuck? Thanks. And if you can't declare what the fuck, can you go? Yeah. Your Honor, can you either tell me what the fuck or can you go? One of those two. So the government argued that the court lacked jurisdiction over the plaintiff's 2024 tax refund claim because it was premature. As for plaintiff's 2021 tax refund claim, the government moved the court to order plaintiff to file a more definitive statement so that the government may, quote, evaluate plaintiff's 2021 claim if she is making one. Your Honor, what the fuck? On January 13th, 2026, plaintiff responded to the government's motions and indicated that she did not oppose either. Accordingly, plaintiff's claims related to her 2024 tax refund are dismissed, and plaintiff is directed to file an amended complaint regarding her 2021 tax refund claim On or before March 9th, 2026. Guess what happens? Just take a guess. Just take a guess what happens. Just, you let me know what you think happens. You let me know, chat. Because what was going on in March? Right. Yeah, no. She didn't file it by the deadline. Yeah, no, she didn't file it by the deadline. The deadline was March 9th. She did not file it by the deadline. No, she did not. No, she did not. We are looking at an April 2nd filing. April 2nd, 2026. Defendant's motion for leave to file defendant's answer to the amended complaint out of time. Wait, no, this is the wrong one. I need the other one. Hold on. Where is the other one? I am missing. Out of order. Where is the order? Here we go. I had them docketed wrong. Apologies, chat. I know. It jumped the shark a little bit. We'll doodly boop. Just like Men in Black doodly boop. It's fine. Most of us are neurospicy. We'll forget because we're listening in the background. Perfect. Guess what she did next, chat? March 11th. Plaintiff's motion for leave to submit amended complaint after the deadline. You knew that's what was coming. You knew that's what was coming. It just wasn't as late. Plaintiff's motion for leave to submit amended complaint after the deadline. Comes now. The plaintiff, pro se, motioning. I don't believe that is spelled correctly, but whatever. Motioning the court for leave to submit an amended complaint 3 days after the deadline on March 12th. On February 18th, hold on, let me fix this real quick. And yes, she puts all her information on these publicly filed documents. I still try to zoom past it. There we go. 3 days after the deadline on March 12th, on February 18th, the court ordered TikToker to file an amended complaint regarding her 2021 tax refund claim on or before March 9th. Due to excessive obligations with cases as a pro se litigant, TikToker was unable to focus on this case and meet the deadline of March 9th. You sued. You sued. You brought this litigation. On February 15th, 2026, TikToker's motion to dismiss was denied in case, Schofield versus TikToker in the defamation case. On February 15th, her motion to dismiss was denied. She was ordered to prepare for a 4-day trial that would occur in Idaho on February 24th as a pro se defendant. She had to fly from Bangkok, Thailand, to Houston, Texas, and then to Idaho. She had to go to Houston, Texas, you guys. I mean, on TikTok, she was saying she wanted to go to the rodeo, but she had to go to Houston. And then to Idaho. And she had to focus on several pretrial motions and prepare for trial. It's like lawyers have to do multiple things at one time. I know. It's weird. The result of the trial was a verdict of $10 million, causing TikToker to then shift focus on essential post-trial motions. Notice what information is left out there? TikToker, without any assistance from anyone, ask your lawyer. Ask your lawyer. TikToker, without any assistance from anyone, was not able to give the necessary attention to this case because she was overwhelmed. We have seen this. We have seen this come up before with missed deadlines repeatedly. In the other case, who said Houston? We have a problem, Sarah. Houston, we have a problem. She chat overwhelmed. If she argued she was an unseasoned lawyer, though, I would give it to her. But I'm an unseasoned lawyer. I would give that to you. I would give that to you. However, you brought this case. So she was overwhelmed. She attempted to email the amended complaint that she had on March 9th, 2026, but the file would not upload during her travels back to Bangkok. She emailed the court pro se inbox, but could not reach the clerk that way. She called the clerk and was told to submit this motion along with her amended complaint, seeking the court's leave to file it due to excusable neglect. TikToker contacted the government, IRS, regarding the motion for an extension of time. TikToker has not heard back, likely due to the government shutdown. Okay. TikToker requests the court allow for the amended complaint to be filed by March 12th, 2026. Should we take a look at the amended complaint? I think that we should take a look at the amended complaint. We're going to do that now. Let's see. I want to try to find the redacted version of this one, though, because there is other information in this. Let me just make sure. This one doesn't have anything other than the top. I don't know where I put that, but I put it somewhere. Apparently not in this file, though. Give me 1 second while I try to find if I save this somewhere else. There's a lot of information on this one. I can just go grab it from the lounge. But there's a lot of information on this one. Nope. Did not pull it up. Oh, there it is. Yay! I do have it. Huzzah! It's just in the wrong place. Which happens sometimes. It's a lot of documents. Thank you, chat. As we have side quested various different ways today. Let me find where this one went. There we go. We're going to go through the overview of the allegations in the amended complaint. So buckle up for WTF did the IRS do this time? Because it's wild. Donis says, sometimes I cannot believe that Emily is reading. It sounds like she's making it up or her own interpretations. I had to look at the document. Holy cow. Correct. It's why I put the documents. It's why I put the documents on the screen. Because sometimes I do read it wrong. And you guys are like, girl, that's $10 million, not $10,000. What we've missed some zeros. That's why I put them up on the screen. Because there are times I will misread like words or letters or numbers, and I don't want to, change the meaning. You've put the comma at the end of the changes the whole meaning. We're back to Hamilton, everybody. Let's continue. Docket 21. Filed March 17th. Wait a second. What date did she say she was going to file this? Didn't you say the 12th? It says March 12th. Filed by March 12th. Please allow me to file it by March 12th. This says the 17th. That's not the same. She's going to be like, time zones. I don't think they work like that. I'm in the future. No, I don't think it works like that. All right. Previous lawsuits. Plaintiff has never begun any other lawsuits in the United States Court of Federal Claims. That is where this is. Statement of the claim. Buckle up, everybody. let's see what happened. The COVID 2019 pandemic is a global outbreak of the I am reading this from the beginning of the statement of claim verbatim. The coronavirus disease 2019, COVID-19 pandemic is a global outbreak of the infectious disease, severe acute respiratory syndrome, coronavirus 2, SARS-CoV-2, parentheses. To control the outbreak, the United States of America declared a public health emergency and issued major disaster declarations for states across the U.S. The state of Louisiana enacted a statewide stay-at-home order of non-essential business and personnel on March 23rd, 2020. TikToker's Louisiana business, to include her LLC, complied with the stay-at-home order. Wasn't it an online business? Okay. As a result, TikToker lost brick and mortar customers, revenue, and self-employment income. The IRS issued tax credits for paid sick and family leave for self-employed individuals in accordance with the America Rescue Plan Act of 2021. The IRS fact sheet of 2022-15. Oh, and. I have questions. Hold on. Ugh. Fuzz. If there are any tax professionals, you are welcome to share your knowledge here. This is not within my purview of what the IRS did and did not do. I'm very much a ask an accountant kind of a girl. So there is that. She filed her 2021 tax return and it was accepted on February 7th, 2024. Oh boy. TikToker claimed paid sick and family leave for self-employed individuals credits on that return. To calculate the credits, TikToker used her 2020 AGI listed on her IRS account, resulting in a refund of $31,000. $603. $31,603. I can see how this got flagged. Instead of processing the tax return, the IRS froze the refund. Misinformed her that her identity was stolen and made her verify her identity in person at a local IRS office. Well, I imagine that requesting over $30,000 in 2024 for a 2021 refund that sounds like it wasn't filed probably did flag the system. Mm-hmm. Instead of processing the return, the IRS froze the refund, misinformed her that her identity was stolen, made her verify her identity in person at a local IRS office. It took several months to get an appointment with the IRS local office because the IRS also froze the tax refund of many other minorities, she says, and made them verify their identities at a local tax office. I think that this happened to a lot of people during this period of time because there was also some rampant fraud going on and people having returns filed under their identity does happen quite a lot. It's a problem. So even filing, this is not legal advice, but even filing an extension can help with that. All right. So she goes on to say that she verified her identity. The IRS put her 2021 tax refund in review. During this time, the IRS admitted that their processes were disproportionately negatively affecting Black taxpayers, disproportionately doing extra reviews and audits of their accounts, withholding their tax refunds, issuing false flags of identity theft, causing them to wait months and in long lines for appointments with the IRS to verify their identity, and denying them COVID credits. That was all one sentence. At least there were commas. Okay. Mama Bear said the IRS also shut down and had about 10 million pieces of unopened mail at the time. There is also that. Okay. She goes on to say that she, negatively impacted by the systemic discrimination, sought help from the IRS Taxpayer Advocate Services in Houston, Texas, due to financial hardship. So at some point, she either moved or I don't know. I'm gonna wait for the government to answer on this one because I don't know and I have questions. I'm not going to speculate. It probably won't help. She says that she followed all the instructions given by the taxpayer advocate to include filing an amended return for the tax year 2021 to correct the paid sick and family leave for self-employment. This is essentially just more. It's like when your teacher tells you that you need more words in your essay, and so you just add in filler. Because this is essentially what was in it before. Just more. She says that the taxpayer advocate informed her not to use her AGI, but to use net earnings from self-employment instead. She amended her 2021 tax return using net earnings from self-employment for the year 2021 instead, correcting the unintentional error. Not intentionally. Her tax refund was reduced to $11,555. Right. 5 months later, the IRS still refused to release her refund for tax year 2021. The taxpayer advocate falsely accused her of being part of, quote, a social media scam and accused her of not having a business. The taxpayer advocate further accused her of filing a fraudulent tax return for the year 2021 without any evidence and based the accusation solely on TikToker's race, she alleges. She goes on to say, after falsely accusing TikToker of fraud, the IRS and taxpayer quote unquote advocate, this is directly ripped from the last one, advocate, threatened to remove all COVID sick leave tax credits from her tax return, or she would have retaliatory audits on previous tax filings. After TikToker sent a demand letter and threatened to sue the IRS due to the discrimination, the IRS did a retaliatory audit on her account, removed all her income for 2021, removed all credits from the 2021 tax year, and assessed her a fraud penalty of $2,311. To overcome financial hardship due to not having her 2021 tax refund, she had to sell her wedding ring, guns, and jewelry. What? D. Marie in the chat said, imagine being falsely accused and having it make an impact on your life. Right? Imagine the harm that it could cause. So she said that she had to sell her possessions. Okay. Sure. She goes on to say that in December 2025, the IRS released her 2024 tax refund and deducted the $2,311 fraud penalty from the 2024 tax refund. She now files this first amended complaint against the United States for the full 2021 tax refund of $11,555 plus interest, court costs, $2,311 for the erroneous fraud penalty, and $27,341 in actual direct economic damages due to the financial hardship caused by not receiving the tax refund. So you had actual economic damages in the amount of $27,000. I just have to check something real quick. So the taxes were done in some way where she thought she was entitled to $31,000. So is the $27,000 in actual direct economic damages due to the financial hardship caused the money that you spent because that's what you thought you were getting refunded? Is that what you spent because you saw the number on whatever form you filled out and were like, oh, I'm going to get that. I'm going to get that $31,000. So that was the spending equated to money that had not hit the bank account yet? That's my question. Ma'am, I have an idea. So there's this YouTuber who goes over financial documents. It might be an avenue to explore on what the bank accounts look like and what the taxes look like. I'm just saying. They're just there might be an avenue there. Content. No, Emily, you said no attention. You're right. You're right. It would bring too much attention. No, you're right. You're right, chat. It would bring too much. You're right. It would bring too much attention. You're right. That would go the opposite of the goal is less attention. Not now. The goal is less attention. Right. Less attention. My bad. I was giggling because what in the world is this? So the IRS is saying, hey, this might be fraudulent. And she's saying, I'm going to sue you. I'm going to sue you is the response to the fraud penalty. And then the money that I wonder if was spent in belief that that money was coming in. You're right, chat. She should just refer back to the cards. Yep. Go look for the cups. See what they say. Maybe some coins. We'll see what happens. Relief. You guys, this is the exact same complaint that was in the first one. This was the exact same complaint that was in, this is the same complaint that was in the first one. Relief. TikToker seeks the court to order the IRS to issue her full tax refund of $11,555 plus interest, court costs, $2,311 for the erroneous fraud penalty, actual direct economic damages in the amount of $27,341, and reimburse all court fees and attorney's fees. What attorneys? What attorneys? But what attorneys? So total. Where are we at? Where are we at? Hold on. Let's see. We've got 1,555 plus 2311. I mean, the fact that she didn't total it up is just truly an annoyance. So 41,207. Excuse me, IRS, you owe me $40,000. However, if I were Schofield's attorneys, I would probably file garnishment, because if she's owed any of this money, I would probably try to grab it. They may not, but if she's going to fight the IRS over money, I would probably just be like, boop. Can we just boop? Can we boop? Can we just boop on into there? Maybe. Let's take a look at the government's answer real quick, because we're going to just take a look at the government's answer real quick. This was filed on April 2nd. This is the one we looked at earlier, because mine were out of order. Docket 22, April 2nd, 2026. This is the IRS filing. Defendant's motion for leave to file defendant's answer. She literally just said the same thing that she said in the previous complaint. And the government was like, hey, sorry, the woodpeckers fighting with the cardinals outside my window. Right. Mm-hmm. It's that time of year that Emily's going to get distracted by the birds. The government said we either need more information or to dismiss. And she filed in paragraph form the exact same thing she had filed before with a skosh more information. Great. The IRS counsel respectfully moves the court for leave to file defendant's answer to the amended complaint out of time. They would like to embiggen their time. In support, defendant's counsel states as follows. Plaintiff filed her amended complaint on March 17th. By operation of this court's rules, defendant's response was due March 31st. Defendant's counsel, however, failed to properly note this deadline. Excuse me, Your Honor. We were overwhelmed. The IRS lawyers, excuse me. Your Honor, we were overwhelmed. We missed the deadline. So this is the IRS saying, hey, you gave her more time to file. We forgot to file. Yeah, we forgot. Ask your lawyer, counsel. Whoopsies. And this is why lawyers often do not stick it to each other over deadlines that are early on in a case, because it does happen. It happens to TikToker more than most, but the IRS whoopsie doodled. Defendant's counsel failed to properly note the deadline and noticed the lapse April 1st. Thought it was a joke, then started to cry, then filed this. That was my speculation. When going through his cases to determine which projects should be prioritized, defendant's counsel's lapse in scheduling can be explained, though not justified or excused, by a densely packed schedule in the time after plaintiff filed the amended complaint, including preparing for taking of an expert deposition on March 26th, attending additional expert depositions on March 24th, 27th, and 30th, personal travel from March 20th to 22nd, which was unexpectedly extended until the afternoon of March 23rd, and a personal medical emergency, which resulted in a hospital stay the evening of March 26th into the morning of March 27th. Right. And what did TikToker say? Your Honor, I am overwhelmed because I'm in trial. And this lawyer's like, so, hey, I have a lot of trials and I was in the hospital. That's a lot of things. I mean, that's a valid amount of things. Does it happen? Yes. Do I think the court's going to have a problem with it? Probably not. Upon discovering the lapse, defendant's counsel drafted the answer on April 1st. The draft answer was then reviewed by defendant's counsel supervisor, and a final version of the answer is attached here too. Defendant's counsel sincerely apologizes to the court and to plaintiff for allowing this matter to slip through the cracks. She should have seen it coming, so it's fine, counsel. Like, she would just, she should have seen it, she should have seen it coming. So, you know. Defendant's counsel sincerely apologizes to the court and to plaintiff for allowing this matter to slip through the cracks. Defendant's counsel thus moves that the answer to the amended complaint be filed 2 days late. Like, actually. Defendant's counsel conferred with plaintiff, proceeding pro se, who does not object to this motion. Of course she doesn't object to the motion. Sorry, my shoe fell off. All right. Let's see the answer that's attached. I haven't seen this at all. Not even a little bit. Let's see. Well, they don't have the fancy font up at the top, so I'm already annoyed. I'm already annoyed by no fancy font. Answer to the amended complaint. I'm very excited that this is here. All right, let's take a look. Because here's the thing. I'm kind of rooting a little bit. Let me know when we get to the end of this answer how you're feeling. I'm kind of rooting for the IRS to pay her and have it garnished so it goes to the professor. That's based on vibes. That's where my vibes are at. My vibes are like, maybe there's a silver lining to suing the IRS. Like, you get the refund, but it immediately gets garnished. Like, that's kind of where I'm at. So let's see. The United States defendant respectfully submits this answer. In the above captioned case, defendant denies every allegation contained therein that is not specifically admitted below. Jurisdiction 1. Defendant includes the headings from plaintiff's amended complaint to facilitate cross-reference between the amended complaint and the answer to the amended complaint. In so doing, defendant does not admit to the accuracy of the headings. Your Honor, we know how to do this properly, but we're not trying to help, and we're not trying to help, and we're not trying to like change things. We're just going along with what she did. We're responding. We're just know that we're lawyers, and that's why we're doing it. Jurisdiction. In response to the first sentence of the first unnumbered... Oh, the lawyer shade. In response to the first sentence of the first unnumbered paragraph of the amended complaint, avers that this court's jurisdiction, to the extent it exists, is based on 28 U.S.C. 1491A. States that the allegations in the second sentence of the first unnumbered paragraph of the amended complaint constitute legal argument and conclusion which require no response. Oh, boy. Parties. In response, I'm going to scroll through that because it has address, but here, let me see if it says anything of significance. In response to the first sentence, the complainant avers that their name is their name with the address listed, correspond with the name and address of a Form 1040 tax return for the 2021 year. The 2021 year that plaintiff filed with the IRS, the defendant lacks knowledge or information sufficient to form a belief. We don't know yet if that's true. Previous lawsuits. They say they haven't filed lawsuits before in this court. Statement of the claim. In response to the fourth unnumbered paragraph of the amended complaint, avers the IRS transcripts for plaintiff's 2021 tax year reflect that a tax return was filed for that period on April 22nd, 2024, denies that a tax return was accepted by the IRS on February 7th, 2024, states that defendant lacks knowledge or information sufficient to form a belief about the truth of the remaining allegations. I don't know who she had a conversation with, if she had a conversation, what she was told. But the tax return was not accepted by the IRS, or they're denying that it was accepted on February 7th. And they say that return was filed in April of 2022. In response to the fifth unnumbered paragraph of the amended complaint, the IRS avers that their transcripts for plaintiff's 2021 tax year reflect that a refund freeze was put in place dated February 15th, 2024, and that an examination of plaintiff's return began on October 25th, 2024. They froze it in February and didn't evaluate it till October? Oh, that is annoying. I don't know if that's a normal amount of time or not, but wow. Okay. They go on to say that the defendant lacks knowledge about the rest of the allegations. In response to the sixth unnumbered paragraph, the IRS has not issued plaintiff a refund based on her 2021 tax return or amended tax return. Is amended not amended? Amended? Maybe? Maybe not? I don't know. Avers the IRS transcripts for plaintiff's 2021 tax year reflect that an amended return was filed on June 17th, 2024, that plaintiff's claimed earned income credit and 3 other credits were reduced or removed from her account, and that a miscellaneous penalty of $2,311 was assessed against her. You mean like not a fraud tax or whatever she called it? They say that they lack knowledge as to the remaining allegations. In response to the seventh unnumbered paragraph, the IRS admits that plaintiff seeks an $11,555 refund for the 2021 tax year plus interest and court cost, a refund of the 2011 related, or a refund of $2,311 related to a penalty, and quote, $27,000. So they're like, yes, she's asking for that. They lack knowledge or information sufficient to form a belief whether plaintiff is entitled to the claimed refund for the 2021 tax year, denies that plaintiff is entitled to the claimed refund of a $2,311 penalty, court costs, and the claimed, quote, direct economic damages, states that the allegation in the seventh unnumbered paragraph that the $2,311 penalty was erroneous constitutes legal argument and conclusion, which requires no response. They're like, nope. And then they state that the defendant lacks knowledge about the rest of the mess. The final paragraph is the prayer for relief, to which no response is required. Let's see. And then their defenses. To the extent plaintiff is entitled to a refund, she is not entitled to a refund of the $2,311 penalty because she has not filed an administrative refund claim seeking such relief. What? They're like, you're not going through the right process. And look, the IRS processes, I imagine, are not easy to navigate without the aid of someone who regularly navigates the IRS. I imagine that that's difficult, but you have to find a professional to help navigate it. And then the IRS is like, excuse me, you're in the blue line. I'm going to need you to be in the green line. No, I know that they're both kind of teal, but you're in the wrong line. I'm going to need you to go to the other line. Go fill out the form. That peak bureaucracy. Go fill out the form. Oh boy. But no, instead, suing the IRS seemed like the thing to do. So let's see what the court had to say. Emily, there's more? Yeah. Emily, you said we weren't going to deep dive this case. Oh no, we haven't gone through everything. This isn't everything in this case. It's just a lot of it. But also, I understand that navigating the IRS is frustrating, and that's why there are professionals to help. I have a lot of very strong opinions about that. I don't think it should be a game of whack-a-mole. I think it is needlessly complex at times. However, we should continue because the court filed, where is it? The court filed their order on February 2nd. Wait, is there a new docket item? Hold on. There might be a new docket item on this. Well, we might have to look at it because we're already here, and why not? I just have to look at what it is. This is the court's order from April 2nd, 2026. After all of that, let's take a look real quick. April 2nd, 2026, document 23. Order on April 2nd, 2026, the government moved for leave to file its answer to plaintiff's amended complaint out of time. Therein, counsel for the government states that though the government's response was due March 31st, counsel failed to properly note the time. Then they noted the rest of what counsel said. Moreover, counsel for requests that the court allow government's response to be filed 2 days late and request plaintiff does not object. For good cause shown, you shall file it by October 3rd. I don't know if I pulled the court order or if there was a court order allowing her to file the amended complaint late, but there must have been because she filed the amended complaint late and then it was answered. So there must have been an order allowing it. Let me take a look. There was, I just didn't have it. Oh, she was allowed to file it before March 19th. So actually, late, but not late because the court allowed it, which is fair. So the court allowed it to be filed on or before March 19th. And then, let's see. Oh, the government just filed the answer that was attached on the docket. So that was the updated filing. So where are we at? Where are we at? Well, the TikToker is suing the IRS. The IRS has responded with what they can answer. The IRS has responded that some of what the TikToker is seeking be returned is not administratively filed properly, and that they don't know if there is a tax return owed. Here's where I'm at. If there are monies owed by the IRS, it could be something that could be garnished by the plaintiff in the defamation case. So there is that. I am going to be keeping an eye because there are a lot of really strong allegations made where the TikToker is saying that she was discriminated against and told to change things on her return and accused of filing a fraudulent tax return and more. But that's not what the IRS is acknowledging. The IRS is acknowledging that there was a tax return filed for the 2021 tax year in 2024, that there may be a return owed, that there was a penalty that was assessed, that she's not entitled to a refund of the penalty, and that they're not paying her an additional $27,000 in costs and economic damages. So the TikToker is alleging that she has been harmed by the IRS and that not getting her refund on time has cost her damages of $27,000. Emily, she's saying that her actions didn't cause any damages. I know. Who knows? Not getting her tax return on time has cost her $27,000 in damages, she says, but the professor just doesn't have any damages. Yeah, the arguments are out of each side of that coin, it would seem. So with that, we are going to be keeping an eye on the TikToker suing the IRS, which is wild. And then we are going to be keeping an eye on and we're going to keep an eye on it because now I'm invested. I just want to know what happens. Like, I just want to know what's happening. That's where I'm at. So with that, I think it's time to get to some questions. So Law Nerds, you've got questions. I've got questions. We've got questions. Let's get to some questions, shall we? We've got to chat. We've got to chat a little bit. So let's chat. All right. Some of you are indicating that you are having some buffering issues. I would just refresh on the YouTube end. I do not see any blips on my end. However, we have seen complaints, or I've seen complaints in the chat kind of throughout the day about some less than smooth experience on the YouTube end. So it seems to be kind of person by person, but YouTube has been pretty glitchy today based on everything that I've seen you guys chatting about in the chat. So with that, we're going to answer some questions as best we can. And then we're probably going to have to just cut because it seems that everyone is having some YouTube issues, but that's where we're at. Juno says, every time Emily says body language, all I could hear was Ursula. Body language. I know and we've had to talk about the IRS. It's Rex Manning Day and YouTube has been glitchy for some of y'all. Stuff was saved weird for me. It's just, what's with today? Like, what's with today? It's just been a day, but we had to follow up on all the TikTok stuff. I was curious. We hadn't had a chance to talk about the $10 million verdict, and I wanted to. But now, you wanted to. I did want to. And now I need all of the transcripts. I do. I need all of the transcripts. We're going to need them for research purposes as we go through post-trial litigation because we don't have video to fact check it. In other cases, we have been able to like rewind the moment and been like, that's not what happened. That is what happened. This person said this. We haven't been able to see it for ourselves. We have reporting of it, but I think the transcripts would be helpful to just like fact check, just line and go take a look. Because at the end of the day, there is a lot of frustration in watching a defamation case play out when the prevailing party is going to have to go through substantial post-verdict litigation to continue to prevail. And it's frustrating to watch. But I also think at this point, we've been covering this since 2022. So we're going to just continue to see what happens because the life of a case is not just, oh, there's a filing, oh, there's a verdict. The life of these cases can be substantial, truly. Auntie Lime said, what is the rationale for no cameras in federal court? I have no idea. And I hate it. I don't know. I don't know how it started. I don't know why it started. I don't like it. I mean, even the Supreme Court has audio only. Like if we could just go audio only, it would be great. Sarah said, I messed up April 8th for May 8th. I got crumble cookies to celebrate Brandon Banfield's birthday and sentencing. Do not worry, Sarah. There is time. Enjoy your cookies, but there is also time to, we've got a discount for you to do some wild grain if you would like to do some wild grain, because we're going to do that for the sentencing on May 8th as well. I have declared it International Law Nerd Cookie Day. So grab your cookies. And we're going to be back here for sentencing on May 8th. Emily, that seems like a celebration of sentencing. I think it is a moment to be thankful that the victims' families will have a chance to talk. We will get to see Judge A again before Judge A retires, and that we will continue to see Joseph Ryan's name cleared in all of this. And we will get to continue to have a very real conversation about the horrificness of this crime that he still maintains he didn't do. And for, Brendan Banfield seems to be a big fan of cookies on his birthday. And so is it a little bit of a petty reminder that that is not going to be available to him? Sure. Yeah, it is. And that's okay because we're big fans of justice. We're big fans of Judge A, and the actions of Brendan Banfield are horrific, calculated, and depraved of human dignity. And we saw Judge A give 10 reasons to Juliana Magalhaes. I'm real interested to see what Judge A has to say to Brendan Banfield. Because Judge A looked at Juliana Magalhaes and said, may it weigh heavy on your soul. Can you imagine disappointing Judge A like that? May it weigh heavy on your soul. That was for Juliana. What is she going to say to Banfield? I don't know, but we're going to find out together. We're going to find out together. And there are times where it just, some of the cases we cover are so incredibly heavy. And we see a completely different side to how people engage with one another. And lately, it has been a lot of domestically related cases. And it is difficult. So taking a moment to acknowledge justice and to celebrate No Cookies for Banfield, and hopefully the victims' families are able to close a chapter. We are going to celebrate with them being able to hopefully close this chapter as the jail doors close behind Banfield, because he's going to be sentenced to life without parole. It's not that he's going to be sentenced. It's what is Judge A going to say? What are the impact statements going to be? And also getting to continue to talk about how much harm was done in that case and others. Truly. Thank you, everybody, for the transcript fund. I appreciate it. Don't worry, we will take care of it. But yeah, we're gonna get some transcripts. Flea Seals said, bedazzling my grad cap for accounting while listening to this in the background. So glad for this stream. Are you now screaming about this is not how this works with the IRS? Probably. J. Michael, good to see you. Said, love the nails. Thank you. Thank you for keeping us updated on all these cases. You are welcome. We've got a lot to circle back to. The docket is long, but tomorrow we're going to side quest to a case we haven't covered yet. So don't even worry. We've got some more side quests. Virginia, thank you for the gifted memberships. Let's see. Destined to Be said, packing my overnight bag for the side quest because suing the IRS is wild. Kristen's Parrot said what? Said we need a members EDB True Events in court. We did a bit of a deep dive in our, I think it was our last members only. I got on a tangent and we tangented very far down the rabbit hole of court stories. I believe it was the last members only live. So yes, there was absolutely some of that for sure. Claire said, hey, from Bonnie, Scotland. Hey, Claire, good to see you in the chat. Liz B, the Perry, Florida. I hope I got that. No, Liz Beth. Sorry, I can't break up words properly. Could she file a lawsuit against the tarot card company for defective cards? Oh boy. Well, the thing about cards is it's about the interpretation, isn't it? So I think they would say it's user error, but oh boy, would that be interesting to see. Like, which deck are we talking about? It would be that court automatically mutes. I was so thankful because I laughed out loud. RK, there are some YouTube is having some platform difficulties. truly. And it's getting a bit worse as we go on. Witchy Jessa said, did she spend the money before she got the refund? That's my guess. That's purely speculation, but that's my guess. Anon Mouse said, this woman is the definition of I reject your reality and substitute my own. Padme said, what happens to the case if the professor can no longer afford her attorneys to keep dealing with the fuckery? I'm not going to speculate. I think her attorneys would not abandon her at this point, because I also do not want the TikToker to think like, oh, if I just drag this out to the end, she'll give up. I think that based on the very low cost that we are seeing, that the attorneys are not going to turn their back on this client. And if she needed to, she could GoFundMe and things like that, because she has had a successful GoFundMe. So she could do that. And I think there would be plenty of people who would say, yeah, I got you on that GoFundMe, myself included. Music to My Soul said, did I celebrate my birthday last week with big cookies? Maybe. Emily influenced me. I might have to get more for May 8th. Look, it's Lawnard Cookie Day. And if cookies aren't for you, you can substitute Lawnard Cookie Day for Lawnard Let's All Have a Snack Together Day. We can do that for sure. All right. With that, we are having all of the buffering issues. I don't know what that's about. I am so sorry with the buffering. I saw a couple super chats that just did not go through on mine. So if I missed it, I am sorry. Players said, not sure if you've mentioned this yet. Let's see if I can pull this up. But have you seen the Harris County judge that went off on the IT guy? I did not see that. I don't think it's in a court with a case that we're covering, but don't fuck with IT. That's a terrible idea. That's a terrible idea. Don't mess with IT. IT has to deal with people all day long saying things like, it's turned on. And then they roll up and are just like, it's not turned on. I have not seen it. I generally, if it's not a case that we're covering, I generally don't do reacts. It's just IT deals with a million people gaslighting them all the time. No, I did that. No, you didn't. I turned it off and turned it back on. No, you didn't. Why are you lying? Yeah. No, don't fuck with IT. Don't fuck with IT. I'll take a look. A lot of you are like, no, you need to look. I'll take a look. But I don't like bad judges. You know how I feel. It is a privilege to be entrusted as a bench officer. Not everyone does well in the big chair. Not everyone has a tolerance for a position where you are given respect without it being earned. Not everyone does well with that. Many do. And I have found some of the best judges I know are people who are like, I didn't necessarily want to be a judge, but a lot of people told me I should be a judge. They are the reluctant judges because they are interested in justice. And then there are judges who are really interested in the black robe and the power that it gives. And I don't love that. So, yeah, it is a thing. And there are some judges that are just difficult. Yeah. And I think we've been very blessed. Well, you've seen my patience level for difficult lawyers and difficult judges. Yeah. But we've gotten to see some really incredible judges. And one of the things I like about what we do, sometimes you don't know how a bench officer is going to be when you jump into a case. And we've gotten to see some really incredible judges, more so than judges who have not been the greatest. And that's been really nice to see, because I do think for the judges that are just not a vibe, there are many more good judges, because overwhelmingly we have seen good bench officers. and it makes the ones that are not great stand out. I am heartened by the fact that we've seen much more good than bad, and that the bad stands out so much. And I hope that it helps with when y'all see the different courts we're in, that it helps pick out what's abnormal. Like, just because a judge is ruling against a party doesn't mean they're against that party. It could just be that the law is not on their side. But then when you see a judge wilding out, you can look at it and be like, that's not normal. I've watched a lot of court, and that's not how this goes. And so there is room to disagree with a judge's rulings and still like the way that they judge. And then when you see a lot of good judges, the bad ones just become more apparent. And I think that that's a much more informed position to be in just as a public, because how do you know how a judge is doing if you've never set foot in court before? It takes a lot of trust and a lot of faith in the system. And I can understand why so many's faith in the system is shaken. But I hope that even when we see a judge like in the Afro-Man case, the jury still got it right. The jury still got it right, even despite the obstacles. And I think that's really heartening as well, that there are times when there are obstacles and it still gets done right. So I do hope that watching cases in courts allows people to see when things go right and when things go wrong. And I really try not to just highlight things going wrong because, like, oh, damn, that's crazy. But then we're still in this TikTok psychic case 5 years later. I know it's a balance, but I try not to just highlight the bad and highlight the good, because Judge M doesn't go viral, right? And if anyone should go viral, it should be Judge M saying, pause, let's focus. But it doesn't, because it's the way things should happen. It's the crazy stuff that goes viral. But if all we see is what's going viral, then we don't see the good. So I try to balance it as well. I saw a message and then my chat completely glitched. So I do not know who sent the message that their kiddo became drum major. Congratulations. It flew by. Congratulations. I am so excited for you and for kiddo. What a great honor. And I'm sure they will be a great leader. Have fun with it. Also, take a deep breath. It's all going to be fine. And no excessive water breaks. Look, these kids will get through band camp. It is okay to just get everybody getting through band camp. It'll be good. Oh, perfect. RK, thank you. Thank you, Miguelina, for pulling it up. Miguelina found it. I could not find it anywhere. Congratulations. I am so excited for kiddo. Pass along my congratulations. It's so good. It's so good. So congratulations. I'm glad I saw it as it zoomed by. Thank you, Miguelina, for finding it. I could not find it. All right. Are we ready to say goodbye? No, we're not. Because, hello, sir. Guardian of Forever 411. It's good to see you. I know they changed all the names. But again, we recognize our friends. It's good to see you, Stephen. Thanks to watching the channel. I realized how important it is to pay attention to judicial demeanor and the power of my vote. This makes me so happy. It's important to me to watch the judge in action before voting. I love that. And there's a lot of opportunities to do so. And I'm really glad judicial demeanor matters a lot. And the way judges treat the individuals in their courtroom tends to be the way they do everything. And we've seen that with Judge M, who's like, that's not Brittany's job. Judge M is like, come through me. My clerk is not doing this for you. The judges that you like to see are protective of their court staff. They will step up to try to fix things. And they treat the people in their courtroom with dignity, even when the people in their courtroom are wilding out. It is truly like being a great referee. Pick a sport. A good referee is rooting for a good, fair game, not one side or the other. A good referee is making sure that the players on the field are safe and calling it like they see it to the best of their ability in the moment. and they are taking their own emotions out of it. So they are just a neutral arbiter of what's happening. So when people yell and scream at them, they are not getting mad. They are just doing their job, and they understand that the people that are mad at them are just mad at the way the game is going. And they take a deep breath. And you can see it with bad referees too. When you see a bad referee, you're like, woo, that sticks out. Same with judges. Law nerds, you guys are absolutely the best. We have much to talk about tomorrow that was informed at the beginning of stream. And then I've got some questions to find out what's going on with the platform today, because it seems to be a little bumpy. But that didn't prevent us from streaming for 4.5 hours. So I've got to go do work. And I will see you tomorrow. It's always a pleasure to be here with you, Law Nerds. Thank you again to Wildgrain. Hopefully this stream stays up and the snippets of Video Killed the Radio Star are going to be fine, because it's Rex Manning Day. Not on Rex Manning Day. I'll see you guys tomorrow. Bye. Thank you for joining me. Make sure you don't miss a live stream or any of the updates on the cases that you care about most with the Law Nerd app at lawnerdapp.com. It's a free download on iOS and Android, so I can keep you in the loop, because you never know when something's going to pop off. Thanks for being here, and thanks for being a Law Nerd.